Good morning, Commissioner Gray. I can't hear you.
Well, that's because I have to unmute.
there you go, sir.
Thank you. Well, thanks.
Audio and video sound good. You're good to go, sir.
Thank you, sir.
Sure. Good morning, Commissioner Hughes.
Good morning, John. How's it
How you
going
doing today? Not too bad. Audio and video look good. You're good to go. Attention, everybody. Last call for audio video check. Turn on your video and raise your hand and I will call on you. Also, please remember to keep yourself on mute, and after you're speaking, please put yourself on mute. We had a little bit of feedback yesterday.
Joanne, just checking in with you, make sure you're ready to go.
I'm ready to go when you are.
Okay, perfect, thanks. Well, we've got about 1 more minute and then we'll get started.
Okay, sounds good.
All right, good morning, everyone. Let's go on the record, please. Before we begin this morning, I'm going to check in with council to see if there are any preliminary matters for my attention.
Nothing from the companies, Chair Mitchell.
Okay, thank you, Mr. Robinson. Anything from the public staff, Mr. Creech?
Not at this time.
Okay.
Thanks.
All right, Mr. Robinson, we are with you. You may call your next witness.
Thank you, Chair Mitchell. Quickly before we call our next witness, just to resolve yesterday's proceedings. So it's our understanding that Mr. Atkins has completed his testimony unless the commission had any more questions for Mr. Atkins. So at this time, Chair Mitchell, companies would move to excuse Mr. Atkins. I believe also council did move in his testimony and exhibits yesterday, but just in the abundance of caution, if that did not happen, I would move that as well.
All right, Mr. Robinson, yes, and I should have been clearer on the record yesterday. Mr. Atkins is excused, and I will allow your motion to admit his testimony and evidence into the record, exhibits into the record, having heard no objection from council.
Thank you, Chair Mitchell. At this time, the companies would call Ms. Melissa Abernathy.
All right, Ms. Abernathy, there you are. Would you raise your right hand, please, ma'am? You affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. You may proceed, Mr. Robinson.
Good morning, Ms. Abernathy. Please state your full name and your business address for the record, please.
My name is Melissa Abernathy, and my business address is 550 South Tryon Street, Charlotte, North Carolina.
By whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas as Director of Rates and Regulatory Planning for North and South Carolina.
Ms. Abernathy, did you cause to be pre-filed in this docket 25 pages of direct testimony and 7 exhibits for DEC and 7 exhibits for DEP?
I did.
Do you have any changes or corrections to your direct testimony or exhibits?
I do not.
Are they true and correct to the best of your knowledge?
They are.
And if I asked you the same questions today, would your answers be the same?
Yes, they would.
Ms. Abernathy, did you also cause to be pre-filed rebuttal testimony consisting of 24 pages and 5 exhibits for DEC and 5 exhibits for DEP?
Yes, I did.
Do you have any changes or corrections to your rebuttal testimony or exhibits?
No, I do not.
Are they true and correct to the best of your knowledge?
Yes, they are.
And if I asked you the same questions today, would your answers be the same?
Yes, they would.
Chair Mitchell, at this time, I would ask that the pre-filed direct and rebuttal testimony and exhibits of Ms. Abernathy be copied into the record as if given orally from the stand today.
All right, Mr. Robinson, hearing no objection to your motion, the pre-filed direct testimony of Melissa Abernathy filed on October 26, 2020 in this docket consisting of 25 pages shall be copied into the record as if delivered orally from the stand. The 7 exhibits to that direct testimony shall be marked as they were when they were pre-filed. Additionally, the 23 pages of rebuttal testimony pre-filed in this docket, in these dockets on January 11th, 2021 shall be copied into the record as if delivered orally from the stand. And the 5 exhibits to that testimony shall be marked as they were when they were pre-filed.
Thank you, Chair Mitchell. Ms. Abernathy, do you have a summary of your testimony?
Yes, I do.
And would you please provide that summary to the commission?
Sure. Good morning. My name is Melissa Abernathy, and I'm a Director of Rates and Regulatory Planning for North and South Carolina, representing both Duke Energy Carolinas and Duke Energy Progress. I am pleased to appear before you today to discuss various aspects of the proposed storm securitization transaction, which will provide significant quantifiable benefits to customers. My direct testimony supports the revenue requirement calculations for the storm recovery charges resulting from the company's proposal to use storm recovery bonds to finance the incremental O&M and capital investments related to Hurricanes Florence, Michael, Dorian, and Winter Storm Diego, as well as accrued carrying charges, as permitted by the securitization statute. The revenue requirements are designed to repay the proposed storm recovery bonds, as well as all upfront and ongoing financing costs associated with the securitization bond structure. Within my testimony, I demonstrate the quantifiable benefits that customers receive through a storm bond issuance as compared to the traditional recovery model. The magnitude of the 2018 and 2019 storms was unprecedented in the company's service territories, resulting in the companies collectively financing approximately $1 billion in storm recovery costs and associated carrying charges. These storms and their costs have been outlined extensively in the current pending rate case dockets and in the associated storm deferral dockets that preceded the rate cases. The storm recovery costs were updated in this docket to include final costs incurred related to the storms, which resulted in an overall decrease in the amount of storm costs from what was presented in the rate case. The public staff previously reviewed the storm costs originally included in the rate cases and found them to be reasonable and prudently incurred. The companies and the public staff agreed on pursuing securitization of these storm costs as outlined in the securitization statute and agreed upon certain assumptions to be used in the calculation of quantifiable benefits to customers. As noted in my rebuttal testimony, over a 15-year bond period, Duke Energy Carolinas expects securitization to provide an approximate $58 million or 31% net present value benefit to customers when compared to traditional recovery mechanisms, while DEP expects securitization to provide an approximate $216 million or 34% net present value benefit to customers when compared to traditional recovery mechanisms. The primary purpose of my rebuttal testimony is to respond to comments from public staff witnesses related to accounting and auditing of the storm cost and financing costs associated with the transaction. Public staff's testimony included accounting recommendations to track and audit the various upfront and ongoing financing costs that are required by each company's separate special purpose entity, as well as comments related to the servicing and administration fees received by each company from its respective SPE. However, it's my understanding that the companies and the public staff have reached a settlement agreement regarding the accounting issues addressed in my rebuttal testimony. I am happy to answer any questions the Commission may have on the settlement and agreements reached therein regarding the accounting of the storm recovery costs and financing costs. In summary, Duke Energy has earned a consistent and strong reputation within the industry for our rapid and capable response to these extreme weather events in North Carolina. The companies and the Commission have an opportunity to use the recently passed securitization statute to provide significant benefits to customers, as well as create a structure in which the company is able to recover its storm costs quickly and efficiently.
Thank you, Ms. Abernathy. Chair Mitchell, the witness is available for questions.
I have one cross-examination, a very harmless question. I know I didn't list it, but Ms. Abernathy, will you agree that the Duke and the public staff had extensive negotiations to come into this settlement, and the persons on the public staff side were Mike Manis and Michelle Boswell that will testify later? And there was a lot of give and take?
I would agree with that.
Thank you. That's all I have.
Mr. Grantmeyer, just so I'm clear, is that all from the public staff for this witness?
Wrong, but yes, that's
Okay.
all we have. Thank you.
Okay, so Mr. Grantmeyer, I heard you say yes, that's all from the public staff for the witness. All right. Sigfur, anything for this witness?
Nothing for this witness. Thank you,
Okay.
Chair Mitchell.
Okay. All right. Mr. Robinson, any redirect on the question?
No redirect, Chair Mitchell.
Okay. All right. I will turn to my colleagues to see if there are any questions from commissioners. Commissioner Brown-Bland.
Chair Mitchell, I have no questions.
All right. Commissioner Gray?
No questions.
Commissioner Clodfelter?
Nothing.
Okay. Commissioner Duffley?
I have no questions.
Commissioner Hughes?
No questions for me.
All right. Commissioner McKissick?
No questions.
All right. Well, Ms. Abernathy, you almost got off pretty easily, but I have some questions for you. I'm not sure if you heard the question I posed to Mr. Atkins yesterday, and I should have held the question for you. But we're interested in the audit that you all have agreed to with the public staff and the settlement agreement that was filed on the 27th. What is your understanding of the scope of the audit that'll be performed on the ongoing financing costs that are incurred associated with these issuances?
Yes, my understanding of the scope of the audit is that it allows the public staff to audit for clerical and mathematical accuracy, as we include those actual ongoing costs into the true-up mechanism, as well as to audit for charges that may be a result of recklessness, willful misconduct, or gross negligence of the companies or the SPE.
Okay, so is that just so I'm clear, is that a less rigorous analysis or a more restricted scope of analysis than would typically be done under a prudency review type analysis?
I would say that standard is less than the standard of a prudency review that's typically applied to traditional utility costs that go through traditional rate making.
Okay, and can you help us understand why it's necessary to have a more limited scope here on these costs than you would than a prudency review, just so my question is clear?
Yeah, sure. So I think it's good to understand the difference between the traditional utility cost and then what these costs represent. So in traditional rate making for traditional utility costs, those are subject to prudence review, and in return, the companies are allowed to earn a return at their weighted average cost of capital through that structure. The standard of review here for these ongoing costs is different just because the structure of the recovery is different through securitization. So these costs are different than traditional utility costs. These are the cost of the SPE and they're required in order to issue the storm recovery bonds. And company witness Atkins went through various reasons why it's important for the SPE to be made whole for their ongoing financing costs, and the reason that it's structured that way to support the structure of the bonds. And it's important that that structure is maintained so that we can pass savings on and achieve the lower cost through the storm securitization statute. And so with regards to the audit that we've agreed to in the settlement, the storm securitization statute allows for review of mathematical and clerical errors through the true-up mechanism process. So that's consistent with the storm securitization statute. And then this audit is also an audit to ensure no charges are a result of recklessness, willful misconduct, and gross negligence, which is in line with the requirements of the servicing and administration agreements of the company. But in summary, it's there to support the structure of this transaction, which is different than traditional recovery.
Okay. Okay, that's helpful. I appreciate that response. Another question that we have for you all, we'll pose the same question to the public staff, but and if you aren't the appropriate witness to respond to the question, just let me know. But as we understand, the proposal, the storm costs will accrue interest or at the weighted average cost of capital up to and until the weighted average cost of capital established in the company's 2017 rate cases, and then at some point in time will accrue interest at the weighted average cost of capital at that which is approved in the current or the 2019, what we're referring to them as, I guess, the 2019 rate cases. So can you help me understand what the company sees as that specific point in time when the transition will occur from one weighted average cost of capital to the next, and so that's my first question. And my second question are the mechanics of that. I mean, it's going to necessarily cause an adjustment in the cost to be securitized. So how will that adjustment occur? And at what point in the securitization process will that occur?
Sure. So to your first question, we will accrue carrying charges at the recently approved weighted average cost of capital from the last rate case up until we implement rates in this rate case. And so we have implemented interim rates associated with these rate cases. And so at that point, when we implemented the interim rates, it was based on the second partial settlement in the rate cases, and we began to accrue carrying charges at that level.
Okay, so since those interim rates are already in effect, is the response then that that these costs would already be accruing carrying charges at that interim weighted average cost of capital?
Yes.
Okay. Okay, thank you.
And if in the final order something needs to change, we would adjust those calculations to reflect the approved weighted average cost of capital approved in this rate case.
Okay, and can that adjustment be affected such that the actual storm costs that are securitized reflect the adjustment, or will the adjustment have to be flowed through one of the mechanisms outside of the actual securitized storm costs? Does that question make sense?
Yes, it'll be adjusted as part of the IAL process prior to issuance of the bond. So
okay,
all of our assumptions around the carrying cost, the date of the issuance of the bond, all of that will be updated so that through the IAL process, there will be a final calculation of what the actual storm recovery charges are that will be recovered through these bonds.
Okay, I got it. That clears it up for me. Okay. All right, that's it for me for you, Ms. Abernathy. I appreciate your responses to my questions. I will check in with council to see if they have questions on any of my questions.
Public staff has none.
Okay, thank you, Mr. Grantmeyer. Mr. Robinson?
Chair Mitchell, no questions based off of your particular questions. I will just make a comment though. Ms. Abernathy is our accountant witness, and I understand that Commissioner Clodfelter asked some questions about this, why we did not include a storm recovery reserve in this docket. If council does not object, I'd like to give Ms. Abernathy, our accounting witness, an opportunity to respond to that question. But again, that's if council does not object.
We do not object.
No
All right,
objection from SIGFR.
Okay, all right, Ms. Abernathy, you may proceed.
Okay, so as the commission is aware, the costs related to these storms were originally included in our original storm deferral dockets and then consolidated into the pending rate cases. And as part of the first partial settlement in those pending rate cases, the companies and public staff agreed to remove those costs from the rate cases to pursue securitization under the securitization statute. And so we are using this transaction to do just that, to pursue securitization of those costs. And we opted not to add in a storm reserve just to not overly complicate this transaction. But we would be open to a storm reserve.
Okay, thank you, Ms. Abernathy. And I realize, Mr. Robinson, I have one more question for your witness. So I'm going to ask my question, then we'll go back through to see if there are any questions on this question. This is a question from the commission staff, Ms. Abernathy, so I'm going to read it. So just bear with me. I want to make sure I get their question answered. All right, so I assume you have your direct testimony in front of you. And you may not need to reference it, but just have it on hand in case you need to refer back to it. But on page 9 of your direct, lines 13 through 16, in response to the question of whether the costs contained in DEC and DEP's storm recovery costs meet the definition of storm recovery costs pursuant to the statute, you state as follows. Finally, the costs eligible for recovery pursuant to the securitization statute that are included in the storm recovery cost are reduced by the highest amount within the normal range of fluctuation included in each company's 2019 rate case at the time of the storms. So here's the question. Can you explain what is meant by this statement and provide an example of the reduction in the costs eligible for recovery with respect to the present dockets?
Yes, so the level of costs that are recovered related to storm recovery activities is set through each rate case. And there's two different numbers that are looked at. There's the average storm cost in the last 10 years, and that's the average of storm costs in the last 10 years sets the level that's included in rates, and then that's reviewed and approved in a rate case. This normal range of storms is, the way we look at that, is the largest year within the 10-year average. And so that's recognizing the fact that some years may have more storm costs than the average and some may have less. And so we look at that normal storm range before we consider whether there's cost to defer in a given year for significant storms. And so in this case, I may not have the specific details of which storm, but for each year, we looked at the storms and what year they were incurred in, where we were in line with that normal storm range, and the amounts we are proposing for recovery of the amounts that are above that amount. And those calculations have been included within the rate case and have been reviewed by the public staff.
Okay, thank you very much for that explanation. All right, questions from council on my question, Mr. Grantmeyer.
Public staff has none.
Okay, Ms. Kress.
SIGFR has none, and my apologies. I was made aware that my camera was not turned on earlier when I was speaking. My bad.
Okay, well, we see you now. All right, Mr. Robinson.
No questions.
Okay, All right. Well, Ms. Abernathy, it appears that you have come to the end of your appearance before us. Council, I'll entertain, or Mr. Robinson, I'll entertain a motion.
Thank you, Chair Mitchell. At this time, obviously, the companies ensure that the witnesses' testimony and exhibits are moved into the record. And at this time, we would reserve the right to call Ms. Abernathy in the event that she is needed.
Okay. Well, Ms. Abernathy, I may have spoken too soon. You are subject to recall, so you may step down for now, subject to that recall. And Mr. Robinson, hearing no objection to your motion, the exhibits to Ms. Abernathy's testimony will be admitted into evidence.
Thank you.
All right. With that, you may step down, Ms. Abernathy, and Mr. Robinson, you may call your next witness.
Thank you, Chair Mitchell. So the company's pleased to state that it has ended its direct and rebuttal case, frankly. And so at this time, I believe the only lingering motions out there is the testimony and exhibits of excused witnesses, Jonathan Bird and Shayna Angers. At this time, we would move that was testimony for those two witnesses and exhibits be moved into the record.
All right, hearing no objection to that motion, Mr. Robinson, the testimony and exhibits of company witnesses Bird and Angers shall be Angers shall be accepted into evidence. Mr. Robinson, we do have a request for you for a late filed exhibit related to the Angers testimony. Would the companies provide as a late filed exhibit a revised Angers Exhibit 2, page 1 of 1, which is an exhibit to the direct testimony, which reflects the matters agreed upon in the agreement and stipulation of partial settlement?
Yes, Chair Mitchell, understood.
Okay. All right. With that, we will turn to the public staff. Grant Maher, they call your witness.
Yes, the public staff would call the panel of Mr. Sutherland and Mr. Heller.
All right, Mr. Sutherland and Mr. Heller, let me identify you on my screen. Let's see, there you are, Mr. Sutherland. There you are, Mr. Heller. All right, gentlemen, would you please raise your right hands? You affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
I do.
All right, Mr. Grantmeyer, you may proceed.
Just for advice, William Grantmeyer will sponsor Mr. Sutherland and Mr. Creech will sponsor Mr. Heller. And we will start with Mr. Sutherland. Mr. Sutherland, will you please state your name and address?
My name is Paul R. Sutherland. My work address is Sabre Partners, 260 Madison Avenue, Suite 8019, New York, New York, 10016.
And you are testifying in this case on behalf of the public staff?
Yes, I am.
Now, did you cause to be pre-filed in this case direct testimony consisting of 43 pages and 10 exhibits?
Yes, I did.
Now, if I were to ask you those same questions again today, would your answers be the same?
Yes, they would.
Madam Chair, I request that his direct testimony be copied into the record as if given orally and that his exhibits be identified.
All right, the direct testimony of the witness pre-filed on December 21st, 2020 in these dockets shall be consisting of 42 pages, shall be copied into the record as if delivered orally from the stand, and the exhibits to that testimony shall be identified as they were when pre-filed.
Now, also on January 26, 2021, did you file errata corrective testimony? And if I were to ask you the same questions today as to the corrective part, would your answer be the same?
Yes, it would.
I believe that's January 6th. January 6th. Apologies.
Okay, January 6th. Madam Chair, I would ask that that testimony be copied into the record as if given orally.
All right, hearing no objection, Mr. Grant Maher, the errata testimony of the witness that was filed with this commission on January 6th, 2021 shall be copied into the record as if given orally from the stand.
Mr. Sutherland, do you have a summary of your testimony?
I do.
Now, you filed with the commission a summary a couple of days ago, and I believe you have a slight correction in your summary. When you get to that point, will you point it out what the correction is?
Yes, I will.
Okay. Please proceed and give your summary. Thank you.
The purpose of my testimony is to discuss and demonstrate how ratepayer benefit from ratepayer-backed bond financing, and more specifically, ways in which the benefit can be measured and maximized through optimal structuring and application of best practices by a properly structured bond team. My testimony focuses on the quantitative analysis of structuring and pricing decisions by comparing past ratepayer-backed bond pricings, both with and without best practices. So by pointing out some misleading testimony by companies' witnesses, my testimony demonstrates the importance of having on the bond team expert representation on behalf of the ratepayer. An undergraduate degree in electrical engineering from Cornell University and an MBA from the University of Chicago, I worked for over 20 years with Florida Power and Light Company, primarily in the area of corporate finance. I then spent another 20 years with Sabre Partners LLC, involved in 13 utility securitization, raising over $9 billion in an advisory role to public utility commissions on behalf of ratepayers. My particular role as senior advisor has been in the area of quantitative analysis. The biggest net present value NPV savings in a utility securitization result from the fact that rating agencies, Moody's, S&P, and Fitch, generally treat utility securitization debt as off-balance sheet, despite the fact that it may not be so for other accounting or regulatory purposes. This is important because utilities set their capital structure, that is to say, their ratio of debt to equity, based on what is necessary to maintain an acceptable bond rating by the credit rating agencies. This means that utilities can issue securitization debt without having to issue a similar amount of equity to maintain what the rating agencies consider the proper debt to equity ratio. Without the need for that amount of equity, there is no associated income tax expense. Another large contributor to NPV savings from securitization comes from the fact that the revenue requirements are generally structured to be levelized like mortgage payments, rather than declining as in the case with traditional utility revenue requirements. With these savings factors intrinsic to all RBB financings in mind, there are two major aspects with which the bond issuer has some ability to affect the amount of additional ratepayer savings resulting from a well-executed securitization financing. The first is the interest rate on the bonds, and the second is the structure of the financing. Decisions on might include the maturity or weighted average life of the bonds and the number and size of tranches or series of bonds. Both the interest rate and the structure are determined as part of the pricing process of bond issuance. The extent to which the pricing process results in savings is determined by the efforts of the bond team prior to and at the time of pricing. Interest rates are established based on a spread in basis points or hundredths of a percent to the rate on a benchmark security. By convention, asset-backed securities, ABS, are generally priced relative to the rate on interest rate swaps, while traditional corporate debt is priced relative to U.S. Treasury bond rates. Utility securitization bonds have usually been priced like ABS, based off of spread to swaps. But the Duke Energy Florida transaction in 2016 was priced using a spread to U.S. Treasury debt. In either case, a securitized debt should be priced relative to a security of the same weighted average life. If there is no such security, then it should be priced based on an interpolated rate between the two nearest in years benchmark securities. While an issuer cannot control the interest rate on the underlying benchmark security at any point in time, the issuer has the ability to achieve attractive spreads to benchmark rates by effective marketing, educating investors about unusually attractive aspects of the RBBs, and by exercising good analytical and negotiating skills. However, in order to achieve the lowest cost for the ratepayer, the bond team should include a representative of public staff or staff's financial advisor, since that is who has the greatest incentive to protect ratepayer interests. This is most important with utility securitization issues because, unlike conventional utility debt, securitization debt is a direct obligation of the ratepayer and not of the utility. Interest rates relative to other securitization finance can be measured by comparing pricing spreads to benchmark rates for transactions over some reasonably stable period of time. Since the comparisons must be for similar weighted average lives, a regression line can be used showing spreads versus weighted average lives and then used to predict pricing spreads for any particular weighted average life tranche. The outcome for a transaction following best practices with active involvement of a ratepayer representative can be compared to the predicted pricing results based on all other securitizations in the same general time frame to calculate the value or the interest rate savings from such best practices. In addition to spreads used at the time of pricing, spreads to other AAA debt securities, such as U.S. agency securities, for example, Federal Home Loan Bank or Tennessee Valley Authority, can be used to judge success both at the time of pricing and thereafter. Various exhibits in my direct testimony illustrate such savings over a variety of transactions, as, for example, Exhibit 7, showing interest savings in the Duke Energy Florida transaction in 2016 compared to all other RBBs from 2010 through 2016. And the diagram shows savings of approximately 30 basis points each on the two longest tranches, which resulted in net present value interest savings of $6.8 million. Sometimes additional savings can be generated simply by changing the number or size of the tranches in a securitization. An example is given from the Duke Energy Florida securitization in 2016 when, at the suggestion of the Commission's financial advisor, a simple change from a 4-tranche to a 5-tranche structure resulted in an additional $3 million net present value savings for ratepayers. Another type of structural change involves extending the final scheduled maturity of the financing. In direct testimony, the companies recommended a 15-year final scheduled maturity for both DEC and DEP, despite the fact that a 20-year structure offers substantially greater net present value savings. My testimony points out several problems with the company's analysis of a 20-year alternative structure and discusses why the company's financial advisor seems inclined to be dismissive of such alternative. In addition to including public staff and/or their financial advisor as part of a bond team, there are 3 other changes suggested in my testimony. The first is to restrict the return on the capital subaccount held and managed by the bond trustee to just actual earnings on investments made in the account rather than a return equal to the rate on the longest tranche of the financing. The second recommendation is to reflect in the financing order a requirement that all so-called tail-end collections of securitization revenues collected after the loans have been paid off will be credited back to the ratepayers. The final recommendation is that to the extent actual marginal servicing and administration costs incurred by the companies, and here there's a change in wording to delete the word exceed and insert the word are less than the assumed annual fee, those amounts will also be credited back to the ratepayer in a timely manner. Because besides these 3 recommendations, is my recommendation that the public staff and its financial advisor have equal authority with the companies regarding all major decisions involving structuring, marketing, and pricing the securities. Beyond that, the Commission should allow best practices as described by witnesses Esera and other public staff witnesses. This completes my summary.
The witness is available for cross-examination.
And I'd like to, now would be a good time to introduce witness Heller as well, would it not?
It would. Please proceed, Mr. Creech.
Thank you, and good morning. Mr. Heller, are you there?
I apologize, I just unmuted.
Good morning, good morning. Mr. Heller, can you please state your name and address for the record?
Stephen Heller, 3 Fairbanks Court, Woodbury, New York.
And you're testifying today on behalf of the public staff, is that correct?
Correct.
Did you cause to be filed in these dockets on December 21st, 2020, direct testimony consisting of 19 pages and no exhibits, corrections filed to that testimony on January 6th, 2021, and further revisions and fully memorialized testimony on January 13th, 2021?
Yes.
Do you have any corrections to your testimony?
There might be one minor correction. At one point, there was a table listing 7 previous transactions that I'd worked on, and there were references to that number 6 a couple of times in the narrative. I then recalled an additional transaction that was added to the table, but the places in the narrative that mentioned 6 weren't corrected to 7. So nothing regarding the thrust of the testimony, but those minor mistakes are still present.
Thank you. And if you were otherwise asked the same questions today, would your answers be the same?
Yes.
Chair Mitchell, at this time, I would move that Mr. Heller's pre-filed direct testimony as corrected and corrected here on the stand be copied into the record as if given orally from the stand.
All right, hearing no objection, Mr. Creech, to your motion, the pre-filed direct testimony of witness Heller consisting of 19 pages as corrected today on the witness stand shall be copied into the record as if delivered orally from the stand.
Thank you. And Mr. Heller, did you have a summary that you would like to share with the commission?
Yes, I do.
Please proceed.
Okay, thank you. I am owner of Analytic Aid, a consulting company. I have approximately 25 years of investment banking experience at firms including Merrill Lynch, Credit Suisse, and Bank of America. My primary responsibilities were structuring asset-backed securities, also known as ABS, such as mortgage, residential and commercial, and non-mortgage, student loan, pharmaceutical royalty, auto, property assessed clean energy, collateralized financings, and developing models used in that structuring. I've also structured 7 issues of ratepayer-backed bonds, 4 while at an investment bank and 3 as a consultant. I was a structuring financial model for the Duke Energy Florida approximately $1.3 billion ratepayer-backed bond offering that received top ratings from Moody's, S&P, and Fitch. It was also one of the longest duration bonds ever structured at 20 years to scheduled final maturity. I worked directly for Tom Heath of Duke Energy and interacted with Sabre Partners as the financial advisor representing the ratepayers. Moment. There are 2 items I want to highlight from my testimony. 1, it does a disservice to ratepayer-backed bonds and the ratepayers who must pay the cost to treat them as ABS. Ratepayer-backed bonds are different from traditional ABS in all material ways that are of concern to investors. ABS are typically described with scenario analysis that certainly include prepayment risk and might also include risk of loss. Even AAA-rated ABS with little or no risk of loss, traded a wider spread, higher than AAA corporate securities like Johnson & Johnson and Exxon, at least in part because of the variability of the timing of principal return. The AAA-rated ratepayer-backed bonds have no material risk of loss of payment variability because of the frequent legislatively mandated and commission-enforced true-up mechanism. Investors can expect to receive the scheduled cash flows with near perfect certainty. Additionally, from my personal experience, I've seen that ratepayers' interests are best served when independent advisors are involved directly in overseeing the structuring process. The lowest cost of the ratepayer may not be the desired structure for the underwriters. As I work, at an investment bank, we may have prepared a preliminary structure with, for example, a 2-year weighted average life tranche of bonds. And I would go to my bank's trader and say, here's a structure with a 3-year weighted average life tranche of bonds with an all-in execution that is, for example, 1 basis point lower. They're very likely to say something like, we already see good appetite for the 2-year weighted average life tranche and 1 basis point is a rounding error. And I might not disagree with them. But somewhere their answer is going to be the same at 2 or 3 basis points, all in, or even more, and they might still think we're at a rounding error, and an independent advisor would be advocating for the lowest cost of the ratepayer. On short maturities, a few basis points may have limited impact. With long maturities of bonds, even 1 basis point could be significant, and it's likely, potentially could be, a couple basis points or more. That's it.
Thank you, Mr. Heller. The witness is available for cross-examination.
All right, Ms. Athens, the panel is available for cross-examination.
Good morning, Mr. Sutherland and Mr. Heller.
Morning.
My questions today will be primarily to Mr. Sutherland, and I just have a few short questions on your testimony. If you could turn to page 11 of your testimony, Mr. Sutherland. So on page 11, you answered the question whether the committee give the companies flexibility to establish the terms and conditions of the bonds. Is that right?
Gentlemen, make sure you are off mute when you are responding.
Yeah, I'm sorry. Yes, that is correct.
And your answer to that question is no, the companies should not be granted flexibility. Is that correct?
That's right, not sole decision-making flexibility. That's correct.
And you go on to state that the exhibits I am sponsoring, and I quote, amply demonstrate the benefits that accrue to ratepayers from providing the public staff and its advisors equal authority with other members of a bond team to make major decisions. Is that right?
That's correct.
And what exhibits are you specifically referring to in this statement?
I'm referring to the exhibits that demonstrate interest rate savings on transactions that have used best practices versus other transactions in the same time frame. And specifically, that would be exhibit number 2 regarding Texas transactions between 2001 and 2006, and exhibit number 7 that demonstrates the Duke Energy Florida transaction in 2016, and also exhibit number 10, which demonstrates interest rate savings in the Allegheny, West Virginia transaction in 2009.
Thank you. So in either of those 3 exhibits, was a state consumer advocate or state agency other than the Utilities Commission a decision maker?
I don't believe so, no. The decision maker, the co-decision makers included Sabre Partners as an advisor to the commission in a similar role to what Sabre Partners would be performing in this case with the public staff.
Thank you. So you would agree that your exhibits only speak to transactions where the commission and either the public utility had decision-making authority?
That is correct because of the different nature of those transaction structure versus the way the public staff operates in North Carolina, which is somewhat different.
And can you elaborate on those differences, please?
Well, in the cases that I referred to, the 3 cases, or the Texas case is the West Virginia case and the Florida case, the commission had on staff a representation that the main purpose and intent was for that staff to represent the ratepayers in a situation such as this. And my understanding is that in North Carolina, the Public Service Commission, the Utility Commission, does not directly represent the ratepayer in a similar manner, but relies on public staff to perform that function.
But were you here yesterday when you heard the testimony of witnesses Rebecca Klein on behalf of the public staff?
Yes, I was.
And were you here when Chair Mitchell asked her about who represented the ratepayers in Texas?
I believe I was.
And Ms. Klein stated that Texas had another state agency that represented their ratepayers and small business customers. Is that correct?
A segment of their ratepayers, yes.
So again, you would agree that your exhibits only speak to instances where the commission or public utilities had decision-making in those utility securitizations.
That's correct.
Thank you, Mr. Sutherland. That's all the questions I have for you today. And Mr. Heller, I do not have any questions for you. Chair Mitchell, thank you.
All right, redirect from the public staff.
The public staff does not have redirect for Mr. Sutherland.
Okay. Questions from the commission, beginning with Commissioner Brown-Bland.
No questions.
All right, Commissioner Gray,
No questions.
Commissioner Clodfelter,
I have nothing.
okay. Commissioner Duffley,
No questions.
Commissioner Hughes,
No questions.
okay. Commissioner McKissick,
Two quick questions, Madam Chair.
yes, sir, please proceed.
And this would be addressed to Mr. Sutherland. Sir, I was just curious, since you note that since Sabre Partners has been serving as a financial advisor to the public staff, and of course, your recommendation is that the public staff be an official party to the bond team, which would have equal decision-making authority. Of course, Duke has suggested that the public staff not be a part of that team formally and having decision-making authority. Do you think that you, or when I say you, I should say Sabre Partners, we conflicted out in the event the commission had its own financial advisor, independent of the public staff, to provide guidance to the commission?
If that financial advisor to the commission, are you asking if that advisor to the commission were Sabre Partners, or
That is correct.
Another?
No, the advisor to the commission was Sabre Partners. Mm-hmm.
No, I don't think that would be a conflict at all. In either case, we would be representing ratepayer interests.
Okay. And you spoke a lot about the decisions that would be made by that bond team. And I guess you envision that they would be involved in the selection of underwriters, perhaps involved in the decision of attorneys that may be a part of this process, establishing, I guess, a marketing plan for dealing with the bonds and things of that sort. When you have been involved in the past, let's say down in Florida, did you address that full range of issues, such as what is being proposed in this case?
I think probably the analysts in the next group, Sabre Partners, like Mr. Esera and the like, can address that better than I, since my role is primarily analytical and quantitative.
I see. Well, very good. I don't have any further questions at this time. Thank you, Madam Chair. Thank you, Mr. Sutherland.
Thank you.
All right, thank you, Commissioner McKissick. And I have nothing for the witnesses, so I will see if council have questions on Commissioner McKissick's questions.
No questions for me.
All right, Mr. Grant Meyer.
Public staff has no questions.
All right, with that, then Ms. Kress, any from you?
Sigler has nothing. Thank you,
Okay.
Chair Mitchell.
Okay. All right, with that, gentlemen, I believe you may step down. Mr. Grant Maher.
Yes, I would move that his testimony, if not already entered into evidence, be entered into evidence, and his exhibits 1 through 11. I believe I said 1 through 10 earlier, but there are actually 11 be entered into evidence. Thank you.
All right, the 11 exhibits attached to Mr. Sutherland's direct testimony will be admitted into evidence. All right, with that, gentlemen, you may step down.
Chair Mitchell, I'd also like to move that Mr. Heller's testimony in summary, and if I may also, Mr. Sutherland's summary be entered into the record. I think we'll also be filing those with the commission.
All right, hearing no objection, Mr. Creech, your motion is allowed. All right, gentlemen, you may step down. Thank you very much for your time this morning.
Thank you.
Thank you.
All right, Mr. Grantmeyer, Mr. Creech, you all may call your next witnesses.
Chair Mitchell, we are calling our finance panel, which is going to be comprised of Joseph Fischera, Brian Maher, Hyman Shlum, and Bill Moore.
All right. Gentlemen, let me identify you on my screen. All right, let's see. Mr. Maher, I need you to turn your camera on. Mr. Moore, let's see. All right, Mr. Moore, I am still not seeing you.
I think I'm on.
Oh, there you are. Okay. All right, gentlemen, please raise your right hands. Do you affirm that the testimony you're about to give shall be the truth, the whole truth, but the truth?
I do.
All right, thank you very much. And gentlemen, I'm getting some feedback, so I would ask that each of you mute yourselves unless you are going through the opening statements with your attorney. So please remain muted until it's your turn to speak. All right, you may proceed, Mr. Grantmeyer and Mr. Creech.
Chair Mitchell, I just want to give you the order of witnesses. It'll be Mr. Fischera, then Mr. Maher, then Mr. Shlum, and then Mr. Moore. And Mr. Creech will be sponsoring Mr. Fischera and Shlum, and I will be sponsoring Mr. Maher and Mr. Moore. So Mr. Fischera is first.
Good morning, Mr. Fischera.
Good morning, Zeke.
Great. Please state your name and address for the record.
My name is Joseph S. Fischera. Business address is 260 Madison Avenue, Suite 8019, New York, New York.
And you're testifying today on behalf of the public staff, is that correct?
Yes, I am, sir.
And did you cause to be filed in these dockets on December 21st, 2020, direct testimony consisting of 68 pages and 6 exhibits, and corrections filed on January 6th, 2021, and revised corrections and fully memorialized testimony on January 13th, 2021, of course, with those 6 exhibits having been filed originally on December 21st, 2020.
Yes, that is correct.
Do you have any corrections to your testimony?
No, I don't.
If you were asked the same questions today, would your answers be the same?
Absolutely, yes, I would.
Chair Mitchell, at this time, I'd move that Mr. Fischera's pre-filed direct testimony and exhibits be copied into the record as if given orally from the stand, pre-filed direct testimony be copied into the record as if given orally from the stand, and that his 6 exhibits be marked for identification as pre-marked in the filing.
All right, Mr. Peach, hearing no objection to your motion, it is allowed.
And Mr. Fichera, do you have a testimony, a summary you'd like to share with the commission this morning?
Yes, I do.
Please proceed.
Good morning. My testimony focuses on the unique situation that the joint petition creates for the commission to consider. Close to $1 billion is proposed to be raised, and the natural question for people who will be responsible for paying it back is at what cost? The commission is being asked to use its powerful regulatory authority in ways that have not previously been done in North Carolina. It will create a bond of unusual strength, a completely separate credit from the companies. The companies do not pay back the bonds. The ratepayers do directly, with an irrevocable charge on their monthly bill. Moreover, this proceeding will establish a template for future issuances of storm recovery bonds, as more damaging hurricanes are expected to occur in North Carolina. In addition to my testimony, the Sainberg team is presenting in-depth testimony from top utility and corporate finance executives, a former utility chief executive officer, chief financial officer, and treasurer, a former state utility regulator who oversaw the establishment of another ratepayer-backed bond program, as well as from an independent modeler of ratepayer-backed bonds, and a former utility equity analyst. These people, with decades of experience, all agree that the ratepayer-backed bonds are unique and require certain best practices to achieve the lowest cost to the customer transaction. Our experience that these 3 simple best practices should be followed to achieve the lowest storm recovery charges for ratepayers. And they are 1, ratepayer representation; 2, a clear decision-making standard; 3, independently verified written certifications. The goal of the financing is for the commission to get the lowest cost of funds available in the capital markets at the time the storm recovery bonds are priced. Cost matters. If cost didn't matter, then the North Carolina Assembly could have allowed the companies to sell the bonds at whatever rate the professional judgment of the underwriters and investors wanted. But the General Assembly did not say that because cost does matter. Now, the capital markets are often thought of as a black box of buyers and sellers rapidly exchanging millions of dollars. They are thought to produce efficient results because each market participant pursues its own economic interest, with full knowledge and understanding of each transaction, so that the prices are determined through perfect competition based on a free flow of information. However, my experience is that this is not the case for the capital markets in general, or the market for securitized storm recovery bonds in particular. Now, ratepayer representation. All top-rated securities, even AAA securities, do not price at the same. There are differing views. Nothing is automatic in the capital market except the self-interest rules. The economic interests of the underwriters and the companies will not necessarily align with the interest of ratepayers. As with publicly offered securities, the underwriters will represent their own economic interests, and the companies will represent their own interests. Unless the commission acts to create a process involving public staff and the commission, the results are likely to be skewed against ratepayer interest. This will affect the pricing, the transaction documents, and every aspect of the deal. Now, nothing will occur without the hard work and collaborative efforts of all the parties involved. The companies, the public staff, and the commission can work together. They can create the balance necessary to manage competition among underwriters and investors. Decisions affecting ratepayers should be made in consultation with an independent advisor with experience in this unique segment of the capital markets and with a specific fiduciary duty to ratepayers. Public staff witness and my colleague Schoenblum describes these best practices in more detail. A clear decision-making standard. This is critical. The standard should be the best possible deal for ratepayers at the time of pricing, the lowest cost of funds that maximizes present value savings to customers. Anything less allows for less than optimal results. You might ask why? Well, very simply, without a lowest cost, best price, present value standard, there is little incentive for any additional effort and hard works. The bonds could be priced quickly and move on. But the simple facts are that unless a market participant negotiates hard on its own behalf with Wall Street, across the table from those sophisticated and large investors with differing views, the market participant will leave substantial amounts of money on the table. Each side is looking out for its own economic interest. The underwriters and investors want the best deal for themselves. Other market participants must negotiate equally hard and be equally diligent to arrive at a fair transaction that achieves the lowest cost to ratepayers and is fair value to the investor. So without a clear and standard and a negotiating position that includes the potential for the issuer and the ratepayer representatives of saying no when evaluating offers, underwriters and investors will have the negotiating leverage to dictate a final cost to ratepayers. Remember, the best way for a homeowner to lose control of the sale of the price of their house is for her to tell prospective buyers that she must sell her house today because she really needs the money now. Pricing leverage will quickly shift. The third and final element of best practices is a basic business principle. Put it in writing, written certifications. The key transaction participants, the companies, underwriters, and an independent financial advisor should deliver to the Commission independent written certifications without material qualifications, confirming what they have done has in fact led to the lowest cost of funds and the lowest storm recovery charges consistent with market conditions at the time of pricing. With these confirming certifications in hand, the Commission then can make the final go, no-go decision. Any prudent person would want it in writing. For example, investors want documentation before they give up their money. They do not rely solely on oral representations before investing. With Sarbanes-Oxley and a heightened need to maintain public confidence in business, written certifications have become a part of normal business best practices. These best practices were successfully implemented with Duke Energy for Florida ratepayers on a similar transaction. North Carolina ratepayers deserve no less. This completes my summary. Thank you.
Thank you, Mr. Esera. The witness is available for cross-examination. We would, however, like to continue on with the presentation of the initial summaries of the panel.
This William Grant Maher, the public staff's next witness to present the testimony is Brian Maher. Mr. Maher, will you please state your name and address? You're muted, I think.
Okay, good. My name is Brian Maher. My address is 8787 Bay Colony Drive, Naples, Florida.
And by whom are you filing testimony?
I'm filing testimony as a senior advisor of Sabre Partners.
And they are the financial advisor to the public staff?
Correct.
Now, did you pre-file in this case direct testimony consisting of 32 pages and 4 exhibits?
Yes.
And if I were to ask you the same questions again today, would your answers be the same?
Yes.
And Madam Chair, we would request that his direct testimony be copied into the record as if given orally, and the 4 exhibits be identified.
All right, Mr. Maher, my records indicate that the witness sponsored 5 exhibits.
I think that's true. I wasn't going to correct it, but yes, there are 5 exhibits.
Okay. All right. Hearing no objection then to your motion, Mr. Grant Maher, the pre-filed testimony of witness Maher, consisting of 32 pages, shall be copied into the record as if delivered orally from the stand. The 5 exhibits to that testimony will be identified as they were when pre-filed.
Thank you. Do you have a summary of your testimony, Mr. Maher?
Yes, I do.
Could you please read your summary?
Yes. My main focus will be the appropriate relationship between 1, the North Carolina Utilities Commission and the public staff and its independent experts and advisors, who I believe are the best placed to be the main representatives of the ratepayers' economic interests. And 2, the other key parties of the transaction, essentially Duke Energy Carolina, Duke Energy Progress, the companies advisors, and the independent banks that will likely underwrite the storm recovery bond issue. A key concept for the Commission to consider is whether or not the parties involved have what is often referred to as a fiduciary relationship, as opposed to underwriters, advisors, companies acting primarily in their own financial interest. In broad terms, a service provider that has a fiduciary responsibility to its client commits to act in the client's best interests to the exclusion of any contrary interests. Where a fiduciary relationship exists, the client should be comfortable that the service provider is looking out for the client's best interests. The issue of whether a fiduciary relationship exists impacts what the Commission should consider in deciding how to evaluate information it receives from different parties in the proposed transaction. In my experience, for example, underwriters claim that they have no fiduciary relationship to the issuers. Underwriting agreements prepared by counsel for the underwriters now typically include a specific declaration that underwriters have no fiduciary relationship with the issuer. Issuers are frequently asked to acknowledge this affirmatively in the underwriting agreement. Bond underwriters will typically propose an offering process including bond pricing, whereby the underwriters use their, quote, professional judgment, unquote, in establishing price guidance and change that price guidance, quote, solely in their professional judgment, unquote. This is what Companies Act witness Atkins has testified. However, the underwriters act in their own benefit and cannot always be counted on to act solely in behalf of the issuer. Pricing is arguably the most important component of offering securities in the market. I believe that this is a compelling reason why bond issuers need to be very active in the offering process to protect their own interests. In response to data request questions inquiring if underwriters of securities have a duty to the issuer and if those securities, and if it is a fiduciary duty, the company's witness Heath stated that the underwriters do not have a fiduciary duty to the issuer. In responding to PS DR2-2G, witness Heath acknowledged that the engagement letters between the companies, Guggenheim Securities and Atkins Capital, do not create a fiduciary relationship between the parties. In contrast, as an advisor to the public staff, Sabre Partners considers itself as having a fiduciary duty to the North Carolina ratepayers. The storm recovery bond transaction is different from normal corporate debt issues, in which the issuer has a direct interest in minimizing the cost of the transaction in order to maximize economics for its shareholders. For traditional utility debt issues as well, incentives exist to minimize the cost of the transaction. Here, the companies propose that the storm recovery bonds will be issued by special purpose entities, SPEs. This is simply a mechanism to facilitate the transfer of funds from the ratepayers to the companies, while the ratepayers alone will ultimately bear all transaction costs and all costs of repaying the storm recovery bonds. The companies will receive the net proceeds of the bonds to recover previously incurred costs. While I don't doubt that the companies would desire that the ratepayers incur low storm recovery charges, the company's main motivation is to receive the debt proceeds in a timely, efficient manner. Therefore, the companies do not share the same incentives to achieve the lowest overall cost of funds. It is left to the Commission and the public staff to ensure that the ratepayers achieve the lowest overall cost of funds and the bonds and the lowest storm recovery charges consistent with market conditions at the time the bonds are priced. I believe that they need to be fully involved in working in a cooperative way with the companies and the company's financial advisor to achieve that objective. That will require optimal structuring and marketing of the storm recovery bond issue. I believe that the bond team for the storm recovery bond issue should consist of companies, the company's advisor, provided that such advisor is not one of the banks acting as underwriter for the transaction, the Commission, either directly or through a designated staff member, the public staff, and the independent advisors and counsel. I believe it is very important for the lead Commission representative to be closely involved in the project. There are many complexities, and this is probably not the type of work that commissioners undertake on a regular basis. It is important that the bond team operate independently and entirely in the interest of the ratepayers and not include any of the underwriting banks due to their inherent conflict of interest discussed above. All members of the bond team should have a fiduciary relationship with either the companies, the Commission, or the public staff. Decisions of the bond team should be a shared responsibility of its members, with the Commission's representative in a position to make the final decision on a timely basis, often in real time during the final pricing process, in the event of any disagreements among bond team members. In my many years at overseeing ExxonMobil's capital markets activities, I learned that bond issues could almost always be done at lower rates than the best market preliminary indications given by the banks. This was true despite the fact that ExxonMobil was a well-known and coveted AAA rated debt issuer. Active involvement by ExxonMobil to create competition among the banks and to demand the best execution consistently added value. It is also true that all AAA and AAA SF, meaning structured finance, rated debt is not viewed alike by investors in the debt capital markets. For example, when I worked at ExxonMobil, AAA rated ExxonMobil or federal agency credits would command better pricing than most AAA rated structured debt securities, which were backed solely by a pool of intangible contract rights, such as mortgages and credit card receivables. In summary, the proposed storm recovery bonds should achieve a AAA SF rating and perform well in the market, but superior performance is not automatic, since all AAA and AAA SF rated bonds do not trade alike. The key takeaway should be that while factors such as underwriters' professional opinions are valuable, underwriters do not have any fiduciary responsibility to the ratepayer. Similarly, the company's primary responsibility is to their own shareholders. Therefore, the Commission, the public staff, and their independent financial advisors are in the primary position of having to look out for the ratepayer's best interests. It's critical that they play an active role in all aspects of the transaction. They must be willing to invest all the time necessary in the structuring and take an aggressive stance during the marketing process to capture the lowest cost of financing and the lowest storm recovery charges for the ratepayers. This should involve full participation in the transaction with the companies and the bond underwriters, and if required, timely decision-making by commission to resolve potential financing issues in the ratepayers' best interests. That completes my summary.
Thank you. The witness would be available for cross-examination after the other two panelists have presented their testimony. Thank you.
Next, Chair Mitchell, we'd like to call up Ivan Shlum. Good morning. Good morning. Mr. Shlum, can you turn up your volume there just a moment? I'll try to do the same on mine, perhaps. Maybe it's me. There we go. Mr. Shlum, please state your name and business address for the record.
How's that?
Perfect. Please state your name and business address for the record.
My name is Hyman Schoenblum. My business address is 260 Madison Avenue, New York, New York, 10016.
And today you're testifying on behalf of the public staff, is that correct?
That's correct.
Mr. Shlum, did you cause to be filed in this
Heath, I'm
docket?
not hearing you.
Can you hear me now?
Yes.
Did you cause to be filed in this docket on December 21st, 2020? Direct testimony consisting of 56 pages and 2 exhibits.
Yes.
Do you have any corrections to your testimony?
No.
If you were asked the same questions today, would your answers be the same?
Yes.
Chair Mitchell, at this time, I move that Mr. Shlum's pre-filed direct testimony be copied into the record as if given orally from the stand, and that his 2 exhibits be marked for identification as pre-marked in the filing.
All right, hearing no objection, Mr. Creech, to your motion, it is allowed.
Thank you. And Mr. Shlum, do you have a summary you'd like to provide?
Yes.
Please proceed.
Good morning. I am a senior advisor to Sabre Partners, LLC. Sabre is an independent financial advisor to the public staff in the proceeding regarding the issuance of storm recovery bonds by Duke Energy Carolinas and Duke Energy Progress. I have 35 years of utility financial experience. I was employed by the Consolidated Edison Company of New York, or Con Ed, in various senior financial capacities, such as treasurer, controller, and vice president of strategic planning. I was also a key member of the investor relations team and met regularly with investors and bankers. I testified in numerous rate cases, as well as proceedings relating to M&A transactions initiated by Con Ed. With regard to ratepayer-backed bonds, I submitted testimony in 2015 in the Duke Energy Florida $1.3 billion transaction, which refinanced the unrecovered costs of a nuclear power plant. In 2018, I submitted testimony in a California proceeding regarding the risks and benefits of securitization. My testimony in this proceeding addresses 3 major issues. 1, the need for commission and public staff involvement in all aspects of the issuance of ratepayer-backed bonds. Number 2, differences between incentives that exist for standard utility bond issuances versus ratepayer-backed bonds. Number 3, the need for a fiduciary relationship between the various participants in the issuance of ratepayer-backed bonds. Commission involvement. I believe that all parties involved in the issuance of these ratepayer-backed bonds should work collaboratively and in a cooperative fashion to structure the transaction. This will ensure that investors and ratepayers that their interests are being protected and will produce a successful transaction with the greatest economic benefit. Since ratepayers are effectively the ones who will repay the debt to bondholders, the Commission must ensure that their interests are best served through enhanced regulatory oversight. The most efficient manner to achieve these goals is through a bond team that includes all participants, including the public staff, its independent financial advisor, and the Commission. This approach worked very effectively in the above-mentioned DEF transaction, which was praised by the markets and the Florida Commission staff as being an efficient process, yielding superior results. It also worked well in other states, as delineated in my testimony. My motto is, why tamper with success? Differing incentives. As a former treasurer, I can attest to the regulatory incentives that standard utility debt issuances have. I was always worried that the New York Commission would second-guess Con Ed's marketing or pricing in future rate proceedings. Thus, we were extremely careful that we should not be exposed to such potential oversight, both in terms of interest rates and fees paid to the underwriters. Ratepayer-backed bonds do not have these regulatory incentives. The North Carolina Utility Commission cannot second-guess the most important aspects of the storm recovery bond transaction in future rate proceedings. The state has pledged not to interfere. Recovery of issuance costs and interest costs are guaranteed. The true-up ensures full cost recovery. As such, it is extremely important that we get it right the first time. The issuance needs to be handled in an efficient manner, yielding the lowest cost possible. Adopting the best practices recommended by SABR and having all parties work in a collaborative manner will, in my opinion, create the appropriate incentives for a successful transaction. My testimony lists several states that have adopted these best practices in their financing orders. I recommend the same in the instant proceeding. Fiduciary relationship. I concur with witness Maher that the various parties to this transaction should have a fiduciary relationship with either the utilities or the Commission. That entails that the companies and the Commission need to receive conflict-free advice from the experts. The parties need to ensure that conflicts of interest are avoided. For example, utilizing an underwriter to also provide consulting advice might yield a conflict, even though witness Heath believes that structuring advisors, quote, are often in the best position, close quote, to be the lead underwriter. Last, it is my opinion that the form of the issuance advice letters, IAL, by the companies needs to be strengthened to include certification that the structuring, marketing, and pricing have storage consistent with market conditions at the time the storm recovery bonds are priced and based on information available through the date of pricing. Furthermore, while the IAL provides some assurance, the Commission should enhance the protections needed to ensure a conflict-free process. By its involvement in the complete process in issuing these bonds and requiring certificates from not only the companies, but also from the book-running underwriters and the public staff's financial advisor. My testimony delineates a number of personal experiences where investment banker assurances were not sufficient in protecting the transaction. This concludes my summary.
Thank you, Mr. Shumblum. Chair Mitchell, the witness is available for cross-examination. However, I believe we have one final panelist.
This is Bill Grantmeyer again, public staff. Mr. Moore, are you online now?
Yes, I am.
And Mr. Grantmeyer, just make sure your camera's on.
Mr. Moore, did you cause to be pre-filed? Please state your name and address.
William Moore, 2764 North Shore Court, Wichita, Kansas.
And by whom are you employed?
Well, I'm retired, but I'm acting as a consultant for Sabre Partners and the public staff.
And did you cause to be pre-filed on December 21, 2020, direct testimony consisting of 16 pages and no exhibits?
Yes.
And if I asked you those same questions today, would your answers be the same?
Yes, they would.
And you have no corrections to any of your testimony, is that correct?
I do not.
And Madam Chair, I would request that his direct testimony be copied into the record as if given orally.
All right, Mr. Grantmeyer, the pre-filed testimony of witness Moore, consisting of 16 pages, will be copied into the record as if given orally from the stand.
Do you have a summary of your testimony?
Yes, I do.
Will you please read your testimony?
I will. Good morning, commissioners. The following is a summary of my testimony. I retired in 2011 as president and CEO of Westar Energy after a 33-year career in the electric utility industry. Most of my career was in the financial area as a finance assistant, treasurer, VP finance, EVP finance, and CFO. During those years, I negotiated terms and conditions for the issuance of over $3 billion of both investment grade and non-investment grade securities, $1.5 billion of bank facilities, over $1 billion of equity, and several other ways of sourcing funds such as power plant sale leaseback, sale of accounts receivable, and floating rate pollution control bonds. My investor relations responsibilities included many meetings with analysts and investors to provide information on our company and to hopefully raise interest in our securities. The purpose of my testimony as a former utility CEO and CFO, I support the need for a bond team. It is the right thing to do for ratepayers. It is also common sense given the unique nature of these ratepayer-backed bonds. The bond team should include active commission, staff, and public staff representation with its independent advisor in all aspects of structuring, marketing, and pricing the proposed storm recovery bonds. Most importantly, the structuring, marketing, and pricing of ratepayer-backed bonds are more complex than that of plain vanilla utility bonds, such as first mortgage bonds. This is because ratepayers are directly responsible to repay the bonds and associated financing costs through a non-bypassable, automatically adjustable rate component. In this case, storm recovery charge, with the commission required to give up future review. It is a good business practice and common sense that the party directly responsible for repaying the bonds, and that's the ratepayer, should be at the negotiating table throughout the many steps in structuring, marketing, and pricing the ratepayer-backed bonds. Everything that occurs in the structuring and marketing of the bonds leads into the most important part, the bottom line of this transaction, pricing. My 33-year experience with Wall Street on many securities offerings has shown me it's not always wise to rely solely on the underwriter's professional judgment
when pricing bonds. Wall Street wants all sales force and investor inputs funneled through the book running manager / underwriters. Westar had an investor relations team that often talked to owners of our securities directly before and after securities offerings. For ratepayer-backed bonds, ratepayer representatives should have eyes and ears on what the underwriters are saying to and hearing from potential investors before floating price talk. Because the financial order is irrevocable, the Commission must give up its regular ongoing review of these costs. The bond team approach would provide independent confirmation that the lowest storm recovery charge, in fact, was achieved. A bond team that includes Commission, staff, and public staff representatives should have the mandate to be involved in firsthand discussions with the sales force and investors to be effective in helping to achieve the lowest storm recovery charge benchmark. This completes my summary.
The witness and the panel are available for cross-examination.
All right, Duke, you may proceed.
Thank you, Chair Mitchell. This panel will have two lawyers asking questions that I will be cross-examining Mr. Moore and Mr. Maher, and Mr. Esera and Ms. Athens will be addressing her questions to Mr. Schoenblum. And I think the order that we're intend to ask our questions is that I will question Mr. Moore first, then Mr. Maher. Ms. Athens will question Mr. Schoenblum, and we'll finish up with Mr. Esera, if that's all right with the Commission.
All right.
Thank you. Mr. Moore, I've got some questions for you, sir. In your testimony, you indicate you have significant experience placing corporate debt into the capital markets. Is that right?
Yes.
And as you mentioned, that experience was gained in the context of your work for Westar Energy and Kansas Gas and Electric, is that right? I'm sorry, did you say yes?
Yes.
Okay, thank you. Would you agree with me that the process used to market, price, and sell long-term corporate bonds is a well-developed one?
I would agree that.
And the principal parties that are typically involved in issuance of long-term corporate bonds are the issuer, the underwriters, and there's often more than one underwriter, and the investors, correct?
That is correct.
All right. And of course, the issuers and the underwriters all have their own counsel as well. Is that correct?
Yes, they do.
Okay. And while the details of each deal and how negotiations proceed may be different, the basic process is that is developed in the capital markets is largely the same. Correct?
It was during my time.
Okay, fair enough. I'd like to talk to you about due diligence a little bit. In your testimony, you indicate a belief that it's necessary for the public staff to conduct due diligence on the bond marketing, pricing, and issuance process, correct?
Yes, I did.
And by due diligence, you mean confirming that what the underwriters, issuers, and issuer advisors tell the public staff about discussions or negotiations with potential investors and their representatives is true. Is that what you mean by that?
I agree with that as far as what they're going to tell them, but also I'm talking about what they heard back from those investors and other people.
Right, which obviously necessitates them to communicate with them directly, correct?
Are you referring to the underwriter or company?
the conversation between the public staff or the public staff representatives and the parties from whom you are seeking confirmation of information that requires them to communicate with each other in order to provide that confirmation that you're discussing, that due diligence.
Were you talking about the public staff?
Yes.
Talking this?
Yes.
Yes, it would require discussions to get the due diligence. I think what we are talking about here is that process being done through their advisors.
Okay. And you also mentioned that it would be important to communicate, and again, this is on page 16 of your testimony, but it would be important to communicate with those outside of the immediate process. Do you recall that statement?
Excuse me, I'll open my testimony.
Sure.
Would you point me to the page again?
Yeah, hold on. I should have had it opened already, but I need my copy. No, public staff testimony. Yeah. Okay. All right. Here we go. Sorry for the delay here. Well, I may have that wrong. So let's go on to the next question. Apologize for that. Would these conversations, the conversations in the conduct of due diligence that you might engage in on behalf of the public staff, would that include communications with potential investor representatives?
Yes.
Okay, and potentially with the investors themselves?
Yes. We'd like to be getting market intelligence as to what they're thinking, what they're hearing, and would like it to be tracked.
Sure, and I'm just trying to determine what the universe is of folks that you believe it would be appropriate to communicate with. So would it also include rating agencies?
If it was necessary as part of the bond team, and that there's questions coming back from the rating agencies regarding the documentation presented to the rating agencies.
And would you might also have discussions with the SEC?
Again, in response to questions that they might ask, and they might reach out directly to us.
Mr. Moore, when you were managing debt issuances for Westar, did you ever allow a third party to conduct this type of due diligence with respect to a security you were issuing?
We did not. We never had anyone asked to participate.
Okay, thank you. In your testimony, you discussed the importance of certification that the statutory cost objectives have been achieved by the participants in the securitization bond issuance. Is that correct?
Yes, I do.
Okay, and is it your understanding that DEC and DEP intend to certify to the commission that the issuance of bonds in this proceeding is consistent with the statutory cost objectives?
I'm not sure how to answer that. I know they've talked about the issuance advice letter, and I'm not fully remembering maybe what they were saying they would say under that kind of a certification.
Perhaps I could add to Mr. Morris that it's consistent with both the statute and the financing order would be the standard, and I think that's what we're all talking about now is what should be in the financing order, as there was a discussion yesterday about the additional conditions based on the, I guess it's called the catch-all thing that the legislature gave the commission to add any conditions that it wanted in order to protect ratepayers or whomever that were not inconsistent. And that was what was done in Florida as well. Their phrase similar to that was in the Florida storm securitization. And that's how the Florida Commission established the lowest cost standard, as well as bond team and various other things. So I think that's for the edification of the commission, that's what we're talking about right here. What would be the certification that would be involved?
Chair Mitchell, I think I may need some help from the commission here. One of the benefits of presenting witnesses in panel format is the ability, particularly on direct and redirect, for the witnesses to comment on each other's testimony or help answer questions. We have on cross, however, it's a little more problematic because we have two lawyers that are attempting to cross-examine these witnesses on their testimony. And our questions, Ms. Athens' questions and my questions, are all directed toward specific witnesses based on their testimony. And what Mr. Fischera just did is in some ways fine, but it's also very problematic for us to be able to engage in effective cross-examination, because to the extent, particularly if I'm questioning one witness and another witness who's handled by Ms. Athens shows up, and she's either forced to cross in the middle of my cross, or I'm forced to cross a witness that I haven't prepared for. So, I mean, I think it's fine for Mr. Creech and Mr. Grantmeyer to ask follow-up questions on redirect. That's obviously their right, but I would ask for some help if we could to have the questions that I ask answered by the witnesses that they're directed to.
I'm sorry, we were advised that we were able to bring up, but the commission, they'll be, whatever the commission says. I'm sorry if I interrupted, but I was advised that was what we've been bringing a panel, that since we were a team, we're able to supplement the things rather than just simply, but whatever the commission would.
Mr. Grantmeyer, would you like to be heard?
Yes, I think it's normal practice before the commission when we have a panel, if another panelist has very pertinent follow-up information, that they be permitted to give it. And we would ask that this practice continue. I do point out that Mr. Fischera is also a witness that Mr. Jeffries will cross-examine, as is Mr. Maher. And Ms. Athens only has Mr. Schoenblum. But we feel that on a panel, it is very important if the another witness has pertinent information that gives information to the commission, that they be allowed to supplement answers.
All right. Thank you, Mr. Grantmeyer. Mr. Jeffries, allowing witnesses to testify or having witnesses testify before the commission in a panel is something that typically occurs around here. It's my understanding and experience that the parties agree to that beforehand. And so, if a member of the panel has a response, let me be clear, so that when questions are asked, they're asked of the panel, not of a particular witness. We are sometimes more relaxed in our enforcement of the panel procedures than in other cases. So I understand the practical difficulties that having a panel of witnesses poses to the cross-examiner. I'll just say, do your best to get through this, and I'll advise other counsel the same. We'll give you the time you need to get through your cross-examination. And with that, we are at our morning break. We will go off the record now. We will resume at 11 o'clock. So we're off and we'll be back at 11 o'clock. Thank you very much.
Thank you.
All right, Joanne, just let me know that you are ready. All right, perfect. Let's go back on the record, please. Before we begin housekeeping, we will break for lunch at 12:30. All right, Mr. Jeffries.
Chair Mitchell, the company appreciates your ruling before the break, and I do have one slight indulgence I would request with regard to that ruling, and that is in order for the company to establish a reasonable record on cross, I would simply ask that the witness to whom my question or Ms. Athens' questions is originally directed, if they could provide their answer before additional answers are provided by the other witnesses. If that's not going to inconvenience anyone, that would help us a lot in keeping the structure of our cross-examination outlines.
Mr. Grant-Meyer.
The public's not opposed that.
Okay. All right. Well, we will proceed as such. Gentlemen, I believe you've heard Mr. Jeffries' request that you all do your best to answer the questions that are directed to you before other members of the panel respond. All right, Mr. Jeffries, you may proceed.
Thank you, Chair Mitchell. Mr. Moore, just a couple more questions for you. I take it that you are familiar with the what the company refers to as the statutory cost objectives that are set forth in GS 62-172. Is that right?
Somewhat. I mean, I've read them and tried to interpret, but the lowest cost storm reserve charge, so lowest storm reserve charge.
Okay, yeah, that's right. And I'll accept that as a paraphrasing of the statutory language. How about that? Were you listening to the hearing yesterday when Mr. Heath testified?
Yes, I was.
Okay, and then you heard him testify yesterday, and it's also in his rebuttal where he indicates that the company will not only comply with that requirement, but will also provide a certificate to the commission regarding that requirement, correct?
I believe I heard that. I thought I heard some different conversation on that, but it sounded to me like they were the only one going to give a certification, not the underwriters, not us, not Sabre Partners, put it that way. So that's what I thought I heard.
All right, thank you. You don't have any reason to believe that Mr. Heath was being untruthful about his intent to comply with the statutory standard or provide a certification to that effect to the commission, do you?
I do not.
That's all the questions I have for Mr. Moore.
The public staff would do redirect after all the, or would the chair prefer that we do redirect now? I would do it after all the panels is gone.
Yeah, I mean, typically, I apologize for interrupting you, Mr. Grant-Meyer. Typically, cross-examination occurs of the panel, and then we'll move to redirect for the panel. So, Mr. Jeffries, let's proceed as such.
Thank you.
Thank you, Chair Mitchell. The next set of questions I have are for Mr. Maher. Mr. Maher, you have quite a bit of experience in issuance of corporate bonds in the capital markets from your time with ExxonMobil, correct?
That is correct.
All right. You, in your testimony and on page 5, you state that as an officer of ExxonMobil, you always expected to. I think I'm feedback. Is everybody else hearing that?
Mr. Maher, if you will please mute. Well, he's muted now. Okay.
Okay, let me try it. Yeah.
All right, Mr. Jeffries, just 1 minute, please, sir. Mr. Maher, we're getting feedback from your line, so we're going to mute you when you are not speaking, all right? So when you speak, you're going to need to take yourself off mute. Mr. Jeffries, you may proceed.
Thank you, Chair Mitchell. Mr. Maher, in your testimony, you state that as an officer of ExxonMobil, you always expected to develop a cooperative and collegial relationship with the banks that underwrote the bonds to achieve the lowest overall cost possible for the financing. Does that sound familiar to you?
Yes. Yes.
And that would be the goal of ExxonMobil when it issued corporate bonds, correct? To achieve the lowest overall cost?
Yes, it would.
Okay. And you don't doubt that this is also the goal of Duke Energy when it issues long-term corporate bonds, do you?
Whoa. Hold on. No, when they issue long-term corporate bonds for themselves, yes, I agree with that.
Okay. When ExxonMobil, when you were issuing long-term debt instruments for ExxonMobil, I assume that you communicated your desire to obtain the lowest cost to your underwriters. Is that correct?
Explain that, if I may. While we were doing direct issues for ExxonMobil under my tenure, particularly in the 1987 to 94 time, all of our issues were done on for standard debt on what we call the negotiated competitive basis. So what that means is that we would have a very collegial representative with all the banks, because there were probably 25 of them that would come in to see us. And we would be watching what they were doing and what underwritings they were doing. And we would pick probably the 10 that were doing the best at the time. And we would talk to them about an issue we wanted to do. And they would all give us preliminary ideas of where we would price, probably in that range of 35, 40 basis points over US Treasuries. And we would talk to them, and then what we would do is we would pick 5 out of the 10 who we thought were doing the best job at that time. And we would say, let's say this was Monday, we would say on Wednesday, 9 o'clock, there's going to be a competition among you 5, and you will have 15 minutes to price, and whoever gets the best price, gives us the best price, we will take out of the 5 of you. So yes, it was collegiate, but we would take the best out of the 5. And as an example, what used to be quotes of 35 to 40 basis points turned out to be a final pricing of 20 to 25, and sometimes even 15 basis points. So what that proved to us is that even though we were collegial and we were friends, when we put the pressure on them, then they would come down significantly in their pricing. So that's the conflict there. And I guess I would have to also, if I could take a second, I talk about being aggressive, and I listened to Mr. Heath's testimony, and he talks about clearly the statute, it talks about consistent with market conditions at the time the bonds are priced. Well, I have a lot of respect for him, and I have a lot of respect for Duke, but I don't define market conditions the same way that he does. Underwriters, in my view, are part of the market, as exemplified by how I just described we used to issue the bonds. So for me, and this goes back to that interesting conversation between Mr. Creech and Mr. Heath, and the commissioners got involved as well, as to whether underwriters would be expected to own parts of the bonds. Now, typically not, but when they bid, I can tell you the winner would probably more often than not wind up holding some of those bonds, because they would bid at such a tight price that they would own some until they could sell them. They would hedge them against the treasuries so they didn't lose large amounts or gain large amounts. But the point is that my idea of an aggressive marketing is not to wait until the underwriter has all the investors ready and then say, okay, that's the best we can do. in the 95.5 example that Mr. Creech gave, if we got there, we would say to the underwriter, if we were doing it, if it were this kind of a deal, we would say, okay, it's time for you to step up. You're making $4 or $5 million on this deal, and it's time for you to step up and take the last 5 because we don't want to pay more for the other 95. So it's a difference in approach as to how you define what market conditions you are and how aggressive you are going to be with underwriters. And we did do that on a couple of occasions where we had more specialized transactions, which involved negotiated deals.
So I think you may have answered a couple of questions that I didn't ask, but that's fine. But to return to the question I was getting to, the process you described that you used with underwriters at ExxonMobil, I mean, the entire purpose of that was to minimize the cost to ExxonMobil of that debt, correct?
Correct.
Okay. And I guess my point is that's the game, right? I mean, that's the game the underwriters and issuers and on the other side, investors play. There's nothing unique or secret about that. That's what these markets do. That's the purpose of this process, correct?
It's the purpose, but the underwriters also have investor clients in their trading desks. And what they tell you is the lowest price most likely is not.
And that's just the negotiating process. You used a good technique to get a good result.
Right, correct. And in this kind of a transaction, we don't have them actually bidding for all the bonds, but we would be there when the pricing is taking place, and we would be making sure how that we got down to the absolute minimum price, even involving underwriter ownership of some of the bonds, before we would say, and now we got the lowest price.
All right, thank you. I'd like to talk a little bit about the duties and interests.
Might I add one thing to that? Having been at Bear Stearns and been one of the banks that have competed with in that process with Exxon. Exxon was a well-known credit and a well-known company. And Brian's description about being able to announce on Monday and do something on Wednesday was able because they were a well-known credit. Here in this situation, it's going to be akin to an initial public offering. This credit for EEC and DEP be established for the first time. Now, the structure, as we said, has been known generally over the past 20 years with 50 billion issued. But when you look at it, there's only about 4 billion in this huge capital markets that is still outstanding. There's only been a few issues. So the marketing period that Brian did with Exxon in the competition was because they were already an established credit. Here, it's going to probably be a little more, and I think Mr. Heath would agree with this. We have to establish the credit, establish this, and distinguish this from others credits, and try to get the AAA that it's not an asset-backed security, it's more a corporate security. I was glad to hear Mr. Heath say that yesterday. That was something that they didn't start out with in Florida saying, but we ultimately got there through our testimony in Florida and through the bond team in Florida. So just got to distinguish short marketing periods for established credits are easy. This will be a new credit, new issue. It will probably take a little more time, but the same sort of competitive nature that Brian is talking about wanting to create is what we think the cooperative and collaborative efforts of an established bond team working under a set of rules and communication, how we would talk to the SEC, how would we talk to rating, everything, be done.
Mr. Maher, when you were involved in this process with underwriters in a competitive process to try to get the best deal for issuances of ExxonMobil bonds, that those underwriters had the same self-interest in those transactions as you've described generally, correct?
Correct.
Okay, and you certainly understood that they had that self-interest at the time you went through this process, correct?
Yes, and that's why we made them bid against each other, because they all knew that each other had the same self-interest.
So you would agree with me, would you not, that at least in in the scenarios you're describing, that the fact that they were self-interested, that didn't prevent you from obtaining what you believe to be the lowest price for the bonds you issued, did it?
It didn't prevent me because, yes, I would agree, and it didn't prevent me because when you have 5 of the top banks bidding against each other, then their self-interest to get the deal drives you to the lowest transaction. It wasn't because they wanted to get there.
Well, of course not. I think we all understand that. In your testimony, you spent some time talking about this concept of fiduciary duty, particularly within the debt issuance markets, particularly with respect to the proposed transaction. And you mentioned some of that in your summary, the fact that it's pretty commonplace to include waivers or disclaimers of fiduciary duty in the documents, the relationship documents between underwriters and issuers and that sort of thing. I mean, this is not something new, right? In the debt markets.
This is not something new in the debt markets, but it's important to know it when the underwriters are giving you their professional opinion about what you should do.
Sure. And in fact, this whole dynamic where underwriters and I guess potentially transactional advisors disclaim fiduciary duty, that came out of a lawsuit that was filed back in 2005, right? You said that in your testimony.
Yes, it certainly did indirectly, because Goldman Sachs apparently did not have the fiduciary responsibility, didn't exercise the responsibility that they should have to the IPO issuing company, and eventually they were called on the carpet for not exercising that responsibility. Yes.
So,
well, and then Hutton and Williams sent out a letter to everybody saying, based on that, we advise that all underwriters should from now on include in their underwriting contracts a disclaimer of fiduciary responsibility, and they all did and have done ever since.
Yeah, us lawyers are bad about that, but the fact that there's not a fiduciary duty between underwriters or financial advisors and issuers, I mean, that doesn't preclude those people from doing their duty in an appropriate way, does it?
No, I think I tried to give that flavor of this in the transaction. Maybe it sounds kind of strong depending on who's reading it in the other direction, but I think underwriters, they all want to be perceived as doing good transactions. Everybody and companies, I'm sure Duke wants to be perceived as doing a good transaction. The real question is that when it comes down to the actual negotiating and how hard you negotiate, there can be a lot left on the table because they don't have the same incentives that we would and this commission would to protect the ratepayer. That's the only point. Yes. Yes. My answer to your question is yes. They do good transactions, but maybe not good enough or as good as it could be.
Yeah, and your own example is an illustration of the fact that, despite the fact that underwriters might have their own self-interest in these transactions, and despite the fact that there's no fiduciary duty, you were able to obtain a result in your finances that you felt represented the lowest price. So, I mean, clearly those factors don't prevent deals from being done appropriately, right?
Well, as I said, I think very clearly throughout my testimony, it does not prevent deals from being done appropriately as long as the issuer works very hard to make sure that it happens.
Sure. Mr. Maher, am I correct in thinking you're not a lawyer, right?
You are correct.
Okay.
I'm sure you figured that out by now.
Well, I'm actually kind of curious, and this a couple of questions here. So you spend a fairly significant portion of your testimony talking about fiduciary relationships. And then on page 12 of your testimony, at least as I read it, and this is lines 3 through 6, you also say that you're not giving an opinion as to whether a fiduciary obligation exists between any parties to the proposed bond transactions. Did I get that right?
Right. I was quoting some things that were quoted by witnesses, but I am not in a position myself, not being a lawyer, to give an opinion. Correct.
Well, so let me ask you this then, because as I read your testimony, about 5 pages later on page 17, at lines 8 through 12, you do make the statement that Sabre Partners has a fiduciary duty to North Carolina customers, or at least they consider themselves to have such a duty. So I was trying to reconcile those two statements and having some trouble doing that.
Could you explain to me a little more about why you're having trouble doing that?
Well, I think we've established you're not a lawyer. We've established that you testified that you're not testifying to who has a fiduciary obligation with respect to the proposed bond transactions. But then on page 17, you turn around and say that Sabre has a fiduciary duty to North Carolina customers. And I guess to me, those statements seem inconsistent.
Well, I say they consider themselves as having it, right? And I guess and so that again is not a definitive thing, but I will tell you that there are other words that they have used with, which are not in here because their contract with the public, with the company. I'm sorry, with the commission, public staff. Is not made public, but so I wasn't going to go read all the stuff, but I can give you an example of some of the words that are in there because I've checked with Mr. Esera and he said that it's okay to do that. He says both Sabre Partners LLC and all the individuals associated with Sabre Partners LLC are free from any conflicts of interest and will provide the public staff and the commission with independent advice with an exclusive duty of loyalty to the public staff and the commission. So that for me sounds very much like what I saw in all the other things that I used and I quoted and used in my examples. And therefore I was able to make the conclusion that I believe that Sabre has that responsibility.
Okay, thank you for that.
And as representing Sabre, as Mr. Maher said, we're advisors. We're not underwriters. We don't have a financial interest. We give advice. And as a lawyer, I don't know what your contract says, but I think there's considered a duty of loyalty and a duty of care to the people. And we put the interests of our clients above, excuse me, above any of our personal interests. And that's what we think a fiduciary duty is. I mean, I think you see a lot of commercials on television these days where some of the brokers, Fisher Investment says, aren't you getting high fees? And they say, no, we do better when our clients do better because we're fiduciaries. And that's sort of what we're saying here, that we're not managing money, but we're giving advice that is in the best interest. And we don't have any interest in the bonds. But we're not trading them, we're not buying them, we don't have interest in Duke stock. And so our duty of care and our duty of loyalty is to our client. Our client's objective is the ratepayers. And so what we feel our duty flows through to the ratepayer. It's just simple as that. Without getting a lot of lawyers involved, I just think that that's the common sense of contracts.
So, Mr. Esera, let me follow up on that real quickly with you, if that's all right.
Of course.
Underwriters have an interest in these transactions because they get paid for the services they provide in conjunction with these transactions, correct?
not just that, they have lots of other interests. I mean, they sell and trade them. They got client relationships. I don't think it's just the fee. It's not a fee for service. Underwriting is not a fee for service like you or I are being paid. Underwriting is something totally different.
So is your testimony that the fees that the underwriters generate in these types of long-term bond transactions are not an important aspect of the benefits the underwriters get from these transactions?
They're one benefit. They get other benefits, but satisfying their customers' needs. You know, I was an underwriter, and you know, I was in corporate finance, not in sales and trading. And look, you're balancing conflicts of interest. You know, you got your sales and trading department. I think I discussed this in my testimony. They're interested, you know, in making money that way. I'm in corporate finance. I had the relationships with the companies. I want to make them happy, but I'm in a separate P&L from my sales and trading force. Different interests are evolved. You know, pushing. When I went to my desk with Exxon, saying Exxon's got an opportunity. I think we should have this really a low spread to win this deal. I got pushed back by the traders saying that's crazy. We're not going to do that. And I one time had a conversation when my boss said to me, you know, you sound like them, Exxon. And I said, well, when I'm talking to Exxon, I'm representing you. But when I'm talking to you, I'm representing them, because we're trying to bring people together here. So the sales and trading department and underwriters, separate, lots of different relationships, lots of things going on. And if you ever notice, the underwriting agreement is not considered a contract in the kinds of contracts you and I have with our clients. There's no services. It simply says we're going to buy these bonds at this price, no representations. And as a matter of fact, the underwriting agreement has Duke indemnifying or protecting the underwriters for all of the materials in the transactions and for anything Duke did wrong. And the only thing that the underwriters indemnify the company for, if you read the underwriting agreement, is the interest rate on the bonds, the names of the firms underwriting, and the amounts that they underwrote. That's it. Anything that the underwriters have done in the sales and marketing, if they did something wrong, they did something that affects the job, they're not indemnifying the company. So the fees associated as part of the compensation. It's also the sales and trading afterwards. It's meeting different client needs. And so you got to balance those interests. In my testimony, we talked about how there was a balance of interests, of self-interest and checks in the traditional debt. The commission has ongoing review, so that there can always have it checked if they found out something else was done untoward, or there was a deficiency. Here, the commission has to give up all of that authority. So we're just saying this is something different. And the same thing with the certification, Mr. Jeffries. I certainly believe that the fact that the company will certify to something and have their opinion doesn't mean that they are violating law. They might just have a different opinion. They might think that they would be very truthful in saying it's their opinion that that's the lowest cost. We might have a different opinion, and somebody else might have a different opinion. That's what makes a market. What you want to do is try to get what we did in Florida, where we got all the opinions lined up, particularly the book runners and an independent advisor, the BIN. We didn't really ask for an opinion from Duke in that, because it would be sort of a self-certification, which we didn't think was important as much as from the book runners and from an independent evaluation. So those fees, yes, part of it, but it's not the same sort of relationship as a service provider, a consultant, an advisor gives. for to their clients. And as you know, this has been a big debate in the industry. Is like when you talk to your broker dealer, is he an advisor if he sells to you or not? Does he have to act in your best interest? There's been a big debate about the best interest rule on Wall Street. Wall Street has pushed back about wanting that to be enforced because they say arm's length transaction. So we're just bringing all these different things together in this transaction and just trying to make it all work in a cooperative and collaborative way. And I think, as Mr. Shlum said in his summary, why, you don't need to fiddle with success. Something that worked in Florida, we think can work here.
So, Mr. Fisher, is Sabre Partners being compensated for their participation in this in this evolution that we're currently undergoing?
Yeah, we're being paid for our services, for our advisory services, as we've been paid in other transactions as well.
And if you were centrally involved in the structuring, marketing, issuance of these bonds, that would be additional work, would it not?
It would be additional work. We're not being paid out of the bond proceeds. We're being paid out of a public staff, a specific statute that allows staff to have. And if we do additional work, yes, we get would have additional compensation.
Do you think? Yeah. So your opinion is you're not being paid out of the bond proceeds. Is that correct?
That is correct.
Who's paying your invoices right now?
I believe Duke Energy is paying them, but it's under a different statute. It is not under the storm securitization statute. I believe the public RFQ related to this transaction, the specifics under North Carolina statute 62-15 H in the whole. It's based on that compensation. So it's not based on the storm securitization statute, and therefore bond proceeds.
So, Mr. Fisher, is it your opinion that the interest that Sabre has and the additional work that they would do if the public staff suggestion were adopted by the commission in this proceeding, that financial interest doesn't create any conflict of interest between Sabre and ratepayers?
No, sir, I don't think it does. The fact of you giving council giving its opinions and in doing its work on the transaction creates a conflict of interest with your client. You're doing work for your client, and as long as you're putting your client's interest first, that's what you got to do.
All right. Thank you, Mr.
I don't think you'd be working. I don't think councils that are going to be working on the documentation or rest implementing the deal have a quote financial interest in the deal. They're doing work for their clients. I hope if there's something different I'm missing, I want to know.
Now I'm going to go back to Mr. Maher at this point. Mr. Maher, on page 19 of lines 8 through 9 of your testimony, you state that in the context of issuing storm recovery bonds, that the company's main motivation is to receive the debt proceeds in a timely, efficient manner. Is that right?
Yes.
Can you, is that a presumption on your part? I mean, you don't have like an email from Mr. Heath to his boss saying that's our main motivation or anything like that, right?
I have no idea. I haven't seen anything like that. Yes, it is. Okay. It is a presumption that that Duke would like to do this transaction, recover the $1 billion, let the bonds then pay them to pay them by the ratepayers, and then use the $1 billion for other purposes. Yes.
All right. Thank you. On page 19 of your testimony, lines 9 through 12, you discuss the rationale as to why you don't believe that DEP and DEC share the same incentives to achieve the lowest cost of funds. You see that?
Yes.
And you state, and I'm going to quote here, if I were going to borrow money and someone else agreed to repay it for me, then I would not be as concerned about the interest rate and other terms of the loan as I would be if I were on the hook to repay the loan myself. So are you saying you would be okay with letting the person who agreed to repay your loan pay more than was necessary? I've only known you for a short time, Mr. Maher. You don't seem like that kind of guy.
No, I never want anybody to pay more than necessary. The real question is how hard I would work on something if someone else was going to repay my debt as opposed to whether it was coming out of my own bank account. Right.
Yeah. So would you have a different approach if you had a standard that was established by statute in negotiating the loan? Would that cause you to be more concerned about what the terms were?
If I had a standard, I would for sure abide by that standard as I interpret it. I think we had this discussion on what we mean by market conditions at the time. And so I might find a different standard of market conditions at the time than if I were responsible for this, in which case I would say, I'm going to get the absolute lowest, and I'm going to get the underwriters to pay for take some of the bonds if I think it's going to get me a lower price. I wouldn't just wait for all the investors to be found at what they want to pay.
Okay. Would you agree with me that the transaction we're currently talking about, that there is a statutory performance standard to obtain the lowest storm charge?
Yeah. Honestly, that's not my area of expertise, but if you could say more about it, you could.
Well, did you hear Mr. Heath testify yesterday that that there is a lowest cost standard and that the company agreed to it, and that he would, or the company would certify that the standard was met as part of the IAL process, and that ultimately the commission would have to approve that certification in order to go forward with did you hear him testify to that?
Yes, I did hear that. And,
okay, thank you.
And I guess that's why I actually feel the way I do, because not disparaging him, and I think he's, as I said, I think he's a very competent person. I think he has maybe a lower hurdle for what the lowest cost standard is, as defined by how he defines you would price the bonds. So I think he would call that lowest standard, and I can't argue if that's what he calls lowest standard. But what I call lowest standard is a more aggressive standard.
All right, thank you. With respect to certification, I would like to read you a statement, and it's short. It's only about 15 words, but I'd like to maybe 20. Read you a statement and ask you whether you agree with the statement or not. And this is the statement. When a person is required to pledge something in writing rather than just orally, and has to account for results later, that person is more likely to take that pledge seriously.
Yeah, I would believe that is true, yes.
Well, that's good, because that statement comes from your testimony on page 22, lines 4 through 7. So I'm glad.
Sounded familiar. Thank you.
All right, good.
Your memory isn't going. That
was a cheap trick on my part. I apologize. That's all the questions I have for Mr. Maher. Thank you, sir. I guess we're going to continue with Cross at this point of the panel. Is that correct, Chair Mitchell?
That is correct.
All right, then at this time, I'm going to hand the mic over to Ms. Athens. I think she's got some questions for Mr. Schoenblum.
All right, Ms. Athens.
Good morning, Mr. Schoenblum. How are you today?
Good morning, Ms. Athens. Great.
Good. So I'd like to start on pages 22 to 23 of your testimony. And I think you answered a similar question that Mr. Sutherland did in your testimony. Should the commission give the companies broad flexibility to establish the final terms and conditions of the bonds? Is that right?
That's correct.
And similar to Mr. Sutherland, your answer to that question was also no, right?
That's correct.
In responding to the question in the negative, are you suggesting that the company shouldn't have flexibility to address market conditions at the time of the bond issuance?
Is your question whether the companies should not have flexibility?
My question was, in answering no to that question in your testimony, are you suggesting that the company should not have flexibility to address market conditions at the time of the bond issuance?
No, I'm not entirely suggesting that. Obviously, any issuer needs to have some flexibility, but at the same time, this is the first securitization issue for both of these companies, and they might not be totally familiar with all of the aspects of securitization, whether it's documentation, market pricing, type of investors that invest in these types of securities. So yeah, flexibility is okay, but at the same time, there are other factors that come into play that may work to limit that flexibility.
So if the public staff were to have decision-making on a bond team and in some way overruled the companies, you would agree with me that that would be limiting the company's flexibility?
The public staff, our position is that the public staff should be part and parcel of the bond team. And the public staff and its advisor will have the ability to review, analyze, do due diligence on all aspects of the bond issuance. And so public staff is going to make recommendations to the company and to the commission as to what its position is and whether it feels that the companies are getting the best deal and offering the best protection for ratepayers in this transaction.
Thank you. Do you have a copy of the securitization statute in front of you?
Yes, I do.
All right. I'd like to turn to section B3, B8. That should be page 5.
Page 5?
Yes, and I'm looking at number 8 towards the bottom.
Okay.
And would you agree with me that it's a requirement that commission include in the financing order the degree of flexibility to be granted to the public utility in establishing the terms, conditions of the storm recovery bonds, including but not limited to repayment schedules and other financing costs?
Yes, that's what the section says, and that's what it reads. But as I explained earlier, there are a lot of other factors involved that may work towards limiting that flexibility. And all we're suggesting is that the utilities not necessarily be the only party making these decisions, and that public staff and its advisors be part of the due diligence process to ensure that the deals are the best deals and that the ratepayers are getting the best transaction.
So would you agree with me, though, that the statute does not grant the public staff or its financial advisors any flexibility?
I wouldn't read it quite that way, because if you look at the provisions establishing the public staff, which is the section 62-15 of the public service law, there are indications therein that public staff can have a role in evaluating financings of the utilities in North Carolina. So they can play a role in addition to the utilities.
But the statute does not specifically grant or make a requirement that the commission must include in the financing order a section on the degree of flexibility to be afforded to the public staff in determining the terms and conditions of the storm recovery bonds.
Well, these are the statutes relating to the storm recovery costs, but it was our recommendation, and the lead into this section talks about the financing order, and what we're recommending is that the financing order be more inclusive and include the public staff and its advisors as part of the process in doing the due diligence and evaluating these transactions in addition to the companies.
So would you agree with me that granting the companies some flexibility can be to the benefit of customers?
I can agree with that statement in its broadest terms, yes.
And is one of your best practices that you list on page 52 to ensure that all statutory limits that benefit customers are strictly enforced?
Page 52?
Yes, sir. Number of your list of best practices.
That's correct. That's what it says, yes.
So why would we not strictly enforce this provision of the statute and grant the public utilities flexibility in establishing the terms and the conditions of the bonds?
As I said a moment ago, our recommendation is that the financing order include other parties that are to be included in this process, in the due diligence process. So if the commission accepts that and issues a financing order that does that, then that will be part of that will become part of the statutory limits that are to be enforced in this proceeding.
So is it your testimony that limiting the company's flexibility would not be otherwise inconsistent with the statute?
In a broad sense, that's probably true, but again, our recommendation is that the financing order should be more expansive and include other parties besides the utilities in the process.
And I think one of the issues here, none of us are all lawyers here, so I think it's really it seems that we're talking past each other about what the definition of flexibility is. I've probably hung around more lawyers than the rest of my team on these issues. I think we're talking about establishing a process where there is flexibility that the company has, but through an established process that has these things go forward, and with the commission always being the decision maker in the end. So we don't think that a bond team process, I think that those words flexibility are in almost every statute that we've dealt with that has had. I think there were certainly in Florida and elsewhere. So that it's part of a process, and that's part of the flexibility. The one thing I can tell you about the North Carolina statute that is different than any other securitization statute over the past 23 years was that it authorized public staff, the independent agency in the commission, in addition to the commission, to hire independent advisors, consultants to be paid out of proceeds. That seemed, we sort of looked at that as a unique thing that the legislature was saying that public staff was going to be part of the transaction because public staff had authorization to be part of the financing costs. So if you go to the definition of financing costs, and this is where I've spent too many times with lawyers, you say what the financing costs are, and then public staff is, and then you go to the legislative fiscal report about what that meant in terms of so you sort of put all this together, you see that public staff should be involved. And then in our testimony, we're just describing a process that affords the commission the decision-making authority, and it also gives the company flexibility. They're proposing different things to be done, but there is a cooperative and collaborative effort that comes together. And I've never seen a situation where we've been in where we overruled something. I don't think that's not the part. It works on a consensus basis. So everybody comes together with that. And that's the best transaction, is where we have agreement, we go forward, independent verifications, and then the commission decides yes, no.
Thank you, Mr. Fischera. And I'm going to turn back to Mr. Schoenblum now. And sticking with the statute, would you agree with me that the statute defines assignee? And that would be on page 1 of the statute.
I'm sorry, I
We lost your sound there.
We lost the sound there for a moment. Can you repeat that, please?
Can you hear me now?
Yes.
So looking on page 1 of the statute, do you agree with me that the statute defines the term assignee?
I see that. That's sub number 2, A2. Is that what you're referring to?
Correct.
Okay, I see that.
And would you agree with me that the statute goes on to define the term bondholder?
That's subsection 2A. I see that.
And would you agree with me that the statute goes on to define the term financing party?
You're referring to subsection 4?
Yes, sir. Yes, sir.
I see that. I haven't read it, but I see that.
And does it go on to also define the term commission?
Which section are you referring to? Sorry. Oh, above that. Section 3.
I believe it's A5.
A5. 1 second. A5, it says financing order.
Are you looking on the first page? And would you agree with me that on the first page, the statute defines the term commission?
Word commission is defined in A3 as the North Carolina Utilities Commission. That's what I see.
But the statute does define the term commission.
That's correct.
And does the statute also define the term public utility?
That's, I believe, subsection 9, public utility.
So would you agree with me that the statute does not define public staff?
Well, again, I would refer back to 62-15, which lays out the duties and requirements for the public staff. And the first sentence of 6215A says there is established in the commission the office of executive director with salary and longevity pay, et cetera. And that talks about and that's the requirement for the public staff. When I first saw that, and I looked at the wording here, and it said in the commission, that kind of led me to believe that the public staff was almost sort of an extension of the commission.
Thank you. Are you aware that the public staff is actually a separate and independent agency of the commission?
That's my understanding, yes.
And looking back to the statute, you would agree that 62-172 does not define public staff or consultant or financial advisor, but it does define position and public utility.
That's correct.
Thank you. So I'd like to turn to your time at Consolidated Edison of New York, which I'll refer to as Con Ed, if that's okay with you.
Sure.
So looking to page 9 of your testimony, you state that you met very frequently with institutional investors, fund managers, stock and bond research analysts, and the media to present Con Ed's financial position to the investment community. Is that correct?
That's correct.
When you met with these people, you met with them on behalf of Con Ed or possibly Con Ed subsidiaries. Is that correct?
That's correct.
And were these meetings in the capital markets authorized by Con Ed or the applicable subsidiary company?
That's correct.
And when working at Con Ed, did you ever participate in an offering of registered securities by Con Ed or one of its subsidiaries?
Yes, I did.
And did you speak with any investors during the marketing of these securities?
When I was treasurer, I was part of a team that marketed the securities to potential investors.
And did that team include anyone who was not working on behalf of Con Ed?
It included Con Ed representatives and underwriters that may have been employed by Con Ed.
And while working at Con Ed, are you aware of an occasion when someone other than the issuer or the underwriter had conversations with investors in a registered securities offering?
Not to my knowledge.
And more specifically, are you familiar with any utility securitization completed by a Con Ed subsidiary?
There was a limited securitization done by one of Con Ed's subsidiaries that was based in New Jersey.
And did Con Ed ever authorize an intervener, including but not limited to a consumer advocate state agency in group in New Jersey to speak with investors during the offering of those securities?
To the best of my knowledge, none was requested.
In that securitization, did a state agency other than the New Jersey Utilities Commission have decision-making?
There were probably other interveners in the proceeding, but of course the New Jersey Commission made the final decisions.
Did the New Jersey Utilities Commission make any decisions with respect to the bond issuances after the financing order was issued?
One second, I'm just reading my response to interrogatory 2-42, which discusses this subject. Can you repeat the question, please?
Did the New Jersey Public Utilities Commission have decision-making authority once the financing order for that securitization was issued with respect to the issuances of the bonds?
I do not recall how that played out, whether the commission made any final determination in that proceeding. I do not recall. I would assume they did, but I can't say definitively.
Can you recall whether there was a bond team at all?
There was no bond team in that proceeding. It was a very small issuance. I think it was about $40 million or thereabouts. It was a very small securitization, limited securitization.
But regardless of size, it was a utility securitization similar to the one that Duke Energy Carolinas and Duke Energy Progress are proposing in this proceeding. Is that correct?
Yes, it was, and there was no bond team. In fact, the whole concept of the bond team has evolved over the years as part of the work being done to establish best practices. So while there was no bond team in that proceeding, I would suggest that the concept of the bond team has come about as a result of trial and error over the years, and my experience with securitization in the Florida transaction, to me, that was sort of the first transaction that I was intimately involved in, and I was surprised by the complexity of the transaction. And as such, I found that the bond team added tremendous value to that process because of the complexity of the issuance. So there may not have been a bond team involved in the Con Ed transaction, but that has changed over the years, and the bond team has become much more acceptable and recognized by everybody that it adds value to the process.
So even though that transaction did not include a bond team, was that securitization successful?
I'm not sure how you measure success. If your measure of success is the lowest cost, I'm not sure that I know the answer to that.
Could you say that there were any rate?
We didn't have any metrics to measure the concept of lowest cost as we do today. I'm sorry.
So would you say that there were, in fact, ratepayer savings, though, that resulted from that securitization?
Absolutely, there were ratepayer savings, but I cannot assure you that they were the maximum ratepayer savings that could have been realized had there been a bond team, for example.
But you would agree with me that that transaction went through and did result in customer savings despite there not being a bond team whatsoever?
That's correct.
No further questions for the witness.
Okay, just so I'm clear, Ms. Athens and Mr. Jeffries, does that conclude Duke's cross-examination of the panel?
No, Chair Mitchell. We have cross-examination from Mr. Fischera.
Okay, proceed, please.
All right, thank you. Mr. Fischera, in your summary, you cited to the DEF bond issuance in Florida as an example of your prior work in this area. Is that correct?
Yes, sir, I did.
Okay. And you represented, I say you, Saber represented the Florida Public Service Commission in that transaction, right?
Yes, that we were hired by them to represent ratepayers in the transaction, yes.
Okay, but your contractors with the commission, correct?
Yes, the commission's staff. And I think they have separate staff, some that support just the commissioners, and then there's the general staff. I think we were the general staff.
Okay, thank you. You did not represent the office or work for the Office of Public Counsel in Florida in that transaction, did you?
No, they were not like public staff is here in the commission. They were a separate entity.
Mr. Fischera, you've presented on securitization to various groups, including the National Association for, well, it's NASUCA. So what is that? The
State Utility Consumer Advocates.
Okay. Do you have our DEC DEP cross exhibit number 6 handy?
No, but I can get it.
Yeah, that would be great if you wouldn't mind.
What is it?
It's your presentation to NASUCA from last year. You may have it memorized. You may not need to look at it to respond.
Yeah, why don't we just go through it if I need to look at it?
Okay, great. You have a slide in there, and it's
excuse me, Mr. Jeffries, my apologies. If I may, I do want to get this in front of Mr. Fischera. Mr. Fischera, that you do have it, obviously, and I emailed it again to you.
That's their cross.
That's right, number 6.
Okay, let me.
That's okay, Mr. Jeffries. Yeah.
Yeah, no, that's great. I appreciate that. I think it's much better if he's got it in front of him.
Okay, it's
6, pre-marked exhibit number 6.
Yes, I see it. Double pages.
Exactly.
Copyrighted. Did you pay us a fee for this or not? All right.
I have no knowledge where this came from, to be honest with you.
Okay. It might have come from our website. I don't know. We put a copyright on it because we're proud of it.
Yeah. Okay, good. Chair Mitchell, we would ask that this be marked as DEC DEP Fischera cross exhibit number 1.
All right, Mr. Jeffries, the document will be marked DEC DEP Fischera cross examination exhibit number 1.
Thank you. Mr. Fischera, could you turn to page 13 and specifically slide 26 of your presentation?
Yes.
Okay. And that slide identifies what you characterize as core best practices.
Yeah, some of the core best practices. Yes, that would fit on one slide. I want to point that out.
Okay.
Excuse me, this is the core reporter. I'm having a little difficulty hearing. If you could just remember to mute yourselves when you're not speaking. There's a lot of feedback.
Okay. Sorry.
Thank you.
Let me just repeat. Yes, the slide 26 is the core best practices that we could summarize on one page, which is an important distinction.
Okay. And so, and I should have done this earlier, I apologize, but the caption of this presentation is investor-owned utility securitization possibilities, processes, and pitfalls, right?
Correct.
And it's relevant because this is the kind of transaction that we're talking about right now in this proceeding, correct?
Yes, there's been a lot of interest over the past 12 months with about bringing securitization not to just what traditional uses were, but things like early retirement of coal plants and other sources, grid modernization, things like that.
Okay, thank you. And so I've looked at these core best practices, and as you say, they're the best practices that can fit on one page. But the first one, customer benefit, is you're citing to the lowest cost standard for ratepayers. Is that right?
Yes, and notice that we also put in present value savings because we think that's important. You know, you might have a misinterpretation of lowest cost by just being the rate. For like a 15-year mortgage has a lower cost than a 30-year mortgage, yet a 30-year mortgage might save you more money over time. So it's important to have the concept of present value in addition to the word cost.
Sure, thank you. On the second is a reference to the authority, and I've paraphrased that as the ability of the commission to include ratepayer protective measures in the financing order. Is that, do you agree that that's what that second best practice is addressing?
Yes, the commission needs, who is going to be the ultimate decider here, and it needs to have the flexibility, not restricted to by the legislature, to do its duty to protect, you know, the public interest by being able to put terms and conditions that it determines is appropriate through the appropriate procedures, is like we're going through now, through a hearing and other things like that, and taking testimony, stuff like that.
Okay, I'm not going to ask you any specific questions about these last three, but I mean, they basically, and I'm paraphrasing here, and let me know if you think I get it wrong, but the third is that you think ratepayers ought to have representation in structuring, marketing, pricing of the bonds. The fourth is that the commission should have access to expert resources. And the final one is that there ought to be a certification of lowest costs. Do you agree with that?
Yes, and it's important to note that the nuances there that are substantive, which is that there are multiple certifications that should line up. In the financial markets, you always get a second opinion. If a company is acquiring another company, they have an opinion, and the acquired company gets an independent opinion to verify. So yes, that's your sort of summary there, but those specifics, I shouldn't say nuances, they're substantive, are important to it.
Sure. Now, these best practices that you've got listed, these are, I guess I would call a SABRE construct. Would you agree with that?
No, I think we've developed them. You know, it was interesting. Somebody else talked to me and said, well, you know, not everybody does this. And they said, well, that's why they're called best practices, because they're relative to how other people have done and what we've seen over time. For example, prior to the Texas transactions, which Becky Klein talked about, of the $50 billion that was issued, $21 billion was issued without any commission involvement or whatsoever. Texas started that process, and then suddenly others started to pick up. New Jersey had an independent financial advisor, Bear Stearns, not me, I wasn't there at the time. And then other states, and then Louisiana, and then Wisconsin, then California. And so these, I think as Heim and Shlum said, these have evolved over time from what people have done. And we've been probably, since we have done the most transactions over the past 20 years, as an independent advisor, they get associated with us, but I think other people have used them.
So I think actually I was asking a little simpler question. You may have just answered it. I mean, these, whether they're in use by other parties or not, these are your best practices, right? I mean, you came up with these. You're the one that decided based upon your experience that these are, in your mind, best practices, right?
In my mind, I think we've testified, and Mr. Sutherland, is that by examining outcomes of other transactions and what has worked and what hasn't worked, we come to the conclusion that these are the best practices and have given testimony to that fact. They're not figments of our mind. They're the results of analysis of transactions over time and consultations with other people like Bill Moore, who, former CEO, I mean, treasurers, other people who've been in the capital markets and involved with these.
I've, it's rare to find someone who won't take credit for something that they've created, but let me try it another way.
I can't take credit for the notion of an independent certification is not, I didn't develop it. It's just been applied here.
Okay. Yeah, you didn't draw these. There's not some NARUC resolution out there saying these are the best practices when you engage in a securitization transaction, or some NASUCA resolution or some independent third party academic discussion that identifies these. So you're not aware of anything like that, right?
No, I'm not aware of those kinds of formal endorsements of best practices in the market. No, I don't think anywhere has that. I don't think the legal profession or the accounting profession or anything else has sort of something written down as best practices.
So, Mr. Fisher, Duke has, as part of their initial filing and direct testimony, they've basically said to the commission, we know how to issue bonds and we believe our interests are aligned with customers. And I know that you may not agree with that second point necessarily, but Duke's
basically my point. Don't assume that I don't agree with it. I do agree with it. That they have some certain experiences and such. I wouldn't make the conclusions. Why don't you ask me the question?
Okay. Well, I was getting there. But then in their rebuttal testimony, and so in their initial proposal to the commission, they basically said, we can do this. They pointed out that the statute doesn't have any express directive for the commission or the public staff to be involved post financing order. But then in their rebuttal, they came back and said, we're okay with a bond team approach. It's a different bond team approach than the public staff has, but Mr. Heath said it yesterday. We have no problem with the commission being a co-equal decision maker on a bond team if the commission decides that that's the role they want to pursue. Do you agree that if the commission had a representative on the bond team with co-equal decision making authority, that they would be able to inform themselves as to whether the bonds were going to be issued consistent with the lowest cost standard for ratepayers?
Yes, the commission could do this on their own with access to the proper expertise. It's not something they do consistent with what the other things they do. And the reason why the Florida Commission and others came to us was they knew that it was outside of their normal course of work, and that they needed individual expertise that was specifically focused on this. So the commission can do this on their own. Public staff, I think the public staff proposal that you're referring to, coming out of our testimony, is simply adapting to the unique aspects of North Carolina that has this entity called the public staff in the commission as an independent agency, but also was authorized by the legislature to engage people as a financing cost and have a duty to intervene. So when we looked at their RFQ from public staff as it came out and familiarized this with us, we thought the reason why we responded to it was, well, this is consistent with sort of the staff that we worked with in Florida, the staff we worked with in Texas, the staff we worked with in West Virginia, the staff we worked in New Jersey, and didn't see this distinction that seems to be going back and forth here between councils. The difference between a public staff and the commission staff. We're not lawyers. You guys will figure that out. But we think it's a distinction without a difference. The commission can do it, or the public staff can do it. The commission can do it by relying on the public staff. Certainly, the commission could do it on their own if they want to, and we'd be happy to work with the commission.
So, in your mind, there's no difference between the commission and the public staff? Is that what you're saying?
No, there's clearly a difference. I mean, the commission is the ultimate decision maker. The public staff is more of an advisor. In now the legal term is intervener in that case, in rates and such. And the rate making process here goes from the financing order all the way to the pricing. So the notion of having the public staff simply in a post financing order process, pre-issuance process, continuing to be involved in the rate making, we thought, and we're not lawyers, is that it's consistent with the legislative mandates of the public staff, and the commission is the ultimate decider. Public staff wouldn't be deciding anything. So, I mean, the commission staff would be deciding, I mean, the commission decides we like this or we don't. The bond team, and I think this is where some confusion might be coming, because when we say a joint decision maker on the bond team, well, the bond team is simply coming up with a structure, a marketing plan, and then that would be presented to the commission to make the decision. And having two people of equal decision-making authority sort of forces a consensus to be made. Now, we know in real life that we can't always agree on something. So we said that part of the process is you have a designated commissioner to be a tiebreaker of that specific decision that couldn't be agreed to. And then that would go forward. And then the commission makes the final decision. Do I accept that or do I not? So there's no like delegated authority to an individual commissioner to decide anything, because it's always the full commission making the decision of whether to accept or reject a transaction, or tell you guys you guys keep negotiating and come back with a joint stipulation for me that I can accept or reject, something like that. So that's sort of the process worked in Florida, and why we mentioned it is, and we were very pleased to hear Tom Heath's testimony yesterday, because adopting the corporate bond index, the bond team, that was not the initial application of Duke Energy Florida before the Florida Commission. That came after our testimony, similar to here, in which we proposed the bond team, and then came after a negotiation that then agreed to a joint stipulation that had all these things, and that we ultimately did. So the fact that now Duke is adopting that is I will take credit for that. Adopting those things was very satisfactory to us. But now that we're making some hyper-technical distinctions between public staff and commission staff, we leave that up to the commission to decide. And we could work for the commission, or we could work for public staff into providing that in that point, the written certifications and bring our experience to it. So I think that's where I think some confusion in this discussion. We clearly see the commission is the decision maker. Public staff is an independent agent. Public staff would be helping put together the transaction, and then the commission votes. That's how it was done in Florida. It was also how it was done elsewhere, but let's just focus on Florida, because that's where Tom Heath and I traveled around the country together, talking to investors and on a road show, and it worked very successfully.
Well, so it's interesting to me. We've had some testimony from Mr. Heath yesterday about Florida, and we've had some testimony from you and some of the other folks from Sabre about Florida today. And I think there's two things I get from it, is that the Duke has obviously said they're comfortable with the Florida model. And you obviously say you're comfortable with the Florida model, but I don't think we're talking about the same thing.
I think we're talking about the same thing, but if the Duke is comfortable with the Florida model, as long as Sabre Partners isn't involved, I think is where we disagree. But the model is about the staff, and now we're getting into the discussion between commission staff and public staff. I know you brought up OPC, the Office of Public Counsel, but they're not the same as public staff here. This is not the same. They're not funded. They're not in the commission. They're apart. You know, I think we tried in our best to adapt to the specific unique situation of North Carolina, which has public staff. The commission didn't do an RFQ. I think they were aware that staff was doing an RFQ for advisors. We looked at it. We thought this was consistent with our business practices where we worked with other commission staff. And as Hyman pointed out, you read the statute that says an independent agency in the commission. And now I'm just a little confused about why we're debating over what the definition of staffs are. The key point is a ratepayer representative. If the commission staff wants to do that right now without public staff, they certainly can do it. We recommend that they have independent expertise. We would be available to do that. We don't think there's any conflict of interest, as Mr. Heath seemed to suggest yesterday, because it's still the same model that worked successfully in Florida.
So I'd like to follow up real quickly on something you just said regarding the commission. If they wanted, or commission staff wanted to do this, then you would be fine with that. And where I was ultimately trying to go here was if the commission took it on itself to play the role that you've advocated, the role that the Florida Public Service Commission did in Florida, that would check all of those 5 best practices that are on your slide 26, correct?
Well, in terms of, I think if you read this financing order similar to the Florida financing order and had all the representations and descriptions and the certifications, mere commission involvement wouldn't do it. I think there's a lot of other details that would be required. But the biggest step is someone representing the ratepayers, however the commission would like that to be, whether it would like it to be its direct staff or public staff, and having access to independent expertise, and then with a duty to the ratepayer, and then those written certifications from the book runner and the underwriters and the independent advisor. I have to tell you, we didn't ask for a certification that Mr. Heath discussed that he's willing to give here in Florida. The reason we didn't ask for it, we didn't think it was that critical, because it was more like a self-certification, which is of limited value. It could be their very opinion, and I don't want to, there's some suggestion that, you know, I think they could believe that that was the lowest cost. And I'm not saying that they're not going to not comply with the statute. They could truly believe that that was the lowest cost. But there could be a different view. And you want to have them all lined up. And when you start doing that, getting people to saying, we need to all agree, or if we're going to put a condition, for example, say I disagreed with something that Duke did, I might condition that in my opinion and say, but for this, we think they got that, and then let the commission decide. They can either go forward with the transaction, even though the opinion was qualified, or they could say, oh, no, we don't want to go forward. Commission authority is paramount. How you get them the best advice as to what the structured marketing and pricing ultimately produced is this process. And I agree with you, Mr. Jeffries, the commission staff can do it, or public staff, or the commission staff working through public staff. There is a couple of different ways of doing it, as long as there's someone representing the ratepayer, fully armed on the other side of at the negotiating table, not outside the room, you know, looking in or checking with it.
Mr. Fisher, do you have access to our DCDP cross exhibit 10?
All right, Mr. Jeffries, I'm going to stop you right now. We're at our lunch break, So we will resume with your next line of questions when we return. We will go off the record now and we will go back on at 2 o'clock.
Thank you.
Thank you. Hey, Barry, your camera's on.
I know, I'm just testing my lighting.
Okay.
Now, when you and I talk, everybody can hear.
Yeah, we can.
That's okay. I mean, we're just not talking about anything.
Yeah.
I'm just testing my.
Yeah, move the camera away from the window, I think.
No, I'm getting up to.
Yeah. By the way, we're broadcasting live to everyone now, just to let you know. Okay.
No, I know. So I'm trying to get a good angle.
Yeah.
Okay. No, I think that's good. Okay.
Okay, I'm going back on mute.
Barry, you okay?
Yeah. Oh, yes. Yeah. As long as if you can hear me and see me, yeah, I hear
Yes,
you.
sir. You're good to go.
Yeah. If you want me, I'm ready. I'm good to go.
All right, no problem.
Okay.
Hey, John, it's Mike Manus, just checking in.
Yep, audio and video look good, sir. You are good to go.
Thank you.
Sure.
John, I'm good.
Yes, sir. You're good to go too.
Thank you, John.
Mhm.
John, how am I now?
You were good. Audio and video good.
All right, I can't use my ear pods for some reason. It was clicking, getting me out of it. So,
No, you're fine. Right now, audio and video look good, so you're good to go.
That's why Apple's stock is down today.
That could be true.
All right, before we begin, Joanne, just checking in with you, making sure you're ready to go. Okay, thank you. All right, it's 2 o'clock. Let's go back on the record, please. Mr. Jeffries, you may continue.
Thank you, Chair Mitchell. Before the break, I had intended to provide and question Mr. Esera about some of the Florida statutes related to the Office of Public Counsel down there. But I think for our purposes, we would be satisfied if the Commission would agree to take judicial notice of Florida Statute 350.0611.
Mr. Jeffries, the Commission will take judicial notice of Florida Statute 350.0611. Did I get that right?
You did.
Okay.
All right. And so, Mr. Esera, I've got just a few more questions for you, if you'll bear with me.
Absolutely, sir.
You would agree with me, would you not, that both DC and DP have significant experience in issuing long-term debt in the capital markets, right?
Traditional utility debt, yes, not securitization debt, but traditional utility debt, absolutely.
Yeah, and they have some experience with securitization debt because of the DEF, the Florida transaction, right?
Well, I don't know how the organization is set up in terms of DEC and DEP. If they're all handled through the parent company, through Mr. Heath, then I would say yes. But if they all have their separate staffs doing their individual issuance, I would say no. But I don't know I just don't know. Some parents allow their subsidiaries to do various things. Others, everything has to be coordinated. If it's coordinated through Mr. Heath, who I worked with closely in Florida, then I'd say that he's got one deal under his belt. Then yes.
All right, thank you. According to Mr. Heath, I believe in his testimony yesterday and his rebuttal testimony, DEC and DP have approximately $50 billion in currently outstanding long-term bonds. Do you recall reading that in Mr. Heath's testimony?
Yes. But one other thing about the experience, I think two other people that worked on the transaction, I think Brian Buckler, who was intimately involved, just left Duke and now is president of Oklahoma Gas. He was the one who did testimony and was the lead. Mr. Heath reported, I believe, to Brian Buckler. He's no longer at Duke. And the general counsel who went through, I think, retired, Bob Lucas. So I think there's new players. There's been turnover at Duke as well. But Tom is still there. And Tom, I know.
Well, I can assure you that Mr. Lucas is still there as well. But
okay.
Could you address my question? And I'm happy to repeat it if you.
Yes, I can't check the exact number, but I know that there's a large amount of outstanding debt on the consolidated balance sheet of all of those. I don't know whether the $50 billion goes specifically to those two utilities.
Right. Mr. Heath also testified that the costs of this debt, even though it's corporate debt, through the rate making process is being paid for by ratepayers, utility ratepayers within the company. You remember that?
Yes, I remember that. I think he left out the fact that it's subject to ongoing review and disallowance, as Mr. Shlum talked about, which is a fundamental difference here. This debt is non-recourse to paid by the ratepayers directly. The debt that Mr. Heath was referring to is debt of the utility that goes through rate cases subject to cost of capital review, prudency, and continuing ongoing review. So it's not the same as this deal where you just tell me what's the interest rate and put the send the bill to the ratepayer. Their debt goes to their balance sheet, goes into their cost of capital, goes into a rate proceeding, may or may not be allowed. What is allowed is, and then it's still subject to review.
Testified that their corporate securities offerings, which we've been talking about.
Beginning of your question, Mr. Jeffries, I lost the beginning of your question. If you could start that over.
Yes. Mr. Fitzgerald, do you also recall Mr. Heath testifying that the corporate debt that we've been discussing, the long-term bonds that we've been discussing, and that are being paid for by Duke's ratepayers through the rate-making process?
Right. I think
well, could I finish my question, sir? Because I haven't gotten to the question.
Okay, I'm sorry, sir.
And the question is, you recall his testimony to that effect, correct?
Yes.
And to your knowledge, has any state commission ever found Duke to have been imprudent in issuing any of that debt?
With that big qualifier, to my knowledge, since I've not done any research on it, I'd have to say yes, but I don't know in terms of all the cost of capital.
Chair Mitchell, that's all the questions we have for Mr. Fitzgerald.
All right, redirect to the panel.
Chair Mitchell, the public staff does not have any redirect for witnesses Moore or Maher.
Okay, Mr. Creech. Mr. Creech, you're on mute.
Thank you. Thank you, Chair. And I do have questions for witness Shlum as well as for witness Esera. Can y'all hear now? Hopefully.
You may proceed, Mr. Creech.
Thank you so much. First, Mr. Shlum, you received any number of questions on statutory questions earlier, and I was hoping we could go back to the statute, the storm securitization statute, just for a moment. And can you read the provision there relating to flexibility? Actually read the whole sentence there, because it does include the word degree in saying degree of flexibility, does it not?
Yes, the lead-in sentence, it's a page with about 8 provisions, but the lead-in sentence on top of the page, and that's page 5, is a financing order issued by the commission to a public utility shall include all of the following elements. And then it goes on to list 8 elements. The 8th one reads as follows: the degree of flexibility to be afforded to the public utility in establishing the terms and conditions of the storm recovery bonds, including but not limited to the payment schedules, expected interest rates, and other financing costs. I would emphasize the word degree, which means that there may be some restrictions.
Okay, and I wanted, you were also asked about definitions in the storm securitization statute. It is true, however, even though the public staff is not defined within that statute, that the public staff is referred to within that statute. Is that correct, to your knowledge?
The storm.
Let me point you. I suppose I can ask you a question on that.
Please.
Excuse me. All right. If you will scroll down to what I think it's just page 2 of the statute initially, subsection 4F. You see that? Any cost incurred by the commission or public staff? Do you see that?
I'm sorry, 4F?
Under definitions, I'm sorry, A4F. A and then number 4 and then F. It's the second page.
I got it. I'm sorry. I was looking in the wrong place. Yes, A4F says any costs incurred by the commission or public staff
Right.
for any outside consultants or counsel retained in connection with the securitization of storm recovery costs.
All right. And let's go down, if we can, actually to page, it's the 15th page of that statute. It's really, just go almost to the very end if you can. And it's going to be subsection or paragraph item N there where it says consultation.
Yes, I see that.
Can you read that, please?
Sure. Consultation. In making determinations under this section, the commission or public staff, or both, may engage an outside consultant and counsel.
Okay. And obviously you're not a lawyer, and I don't want to be too, it's the right word. I want to say this in the right way, but presumably the North Carolina General Assembly knew of the public staff and those making those two reference, wouldn't you say?
Absolutely. They established the public staff in another area, but obviously in the storm recovery statute, they obviously knew of the public staff. There's no doubt in my mind.
And it'd be fair to say that they contemplated certainly in this unique first storm securitization offering a role, whatever the commission may decide, for the public staff.
It certainly seems that they contemplated a role for the public staff. That's correct.
All right. Thank you. Now, Shlum, you were also asked about just briefly about one offering in the state of New Jersey. I think it was a $46 million offering. Just to be clear, while that offering did have an underwriter, it was a limited public offering under Section 144A. Is that? Let's see here. I think that's right. Of the SEC.
That is correct. It was filed under Section 144A. It was not registered with the SEC, but it was a limited offering, and it used Citigroup as the underwriter. And it was a private placement.
All right. Now, a lot of your testimony relates to best practices and certainly various public staff witnesses. And we got some questions on that today. And at times, it's barreled down to a slide or other things. But I was hoping to see if we can kind of visualize that for folks. And Chair Mitchell, if we can, I would like to bring up Public Staff Redirect, pre-marked Redirect Exhibit 38. That's on page 1906 of the combined. It's a Barclays Capital PSE and G spread summary.
And I have ready access to that.
I'm sorry, you do or you do not?
I do not. I'm familiar with it, but I do not have ready access to it.
Well, then that is I'm sorry about that. I'll send that right over to you. Just one moment. And hopefully we'll have time while other folks pull theirs together.
All right, Mr. Preacher, you're going to seek to have this document introduced?
Yes.
All right, let's get it named then.
I would like to name this document as Public Staff Shlum Redirect Exhibit 1.
All right. Document will be identified as public staff, Schoenblum, redirect, exhibit 1.
Mr. Schoenblum, you may have that in front of you now, or it's coming. You're familiar with this document, are you not? The Barclays Capital.
I'm opening it up right now. Yes. I have that.
Okay, and
yes,
let's turn over to the next book. Tell us, what is this, Mr. Schoenblum? You can pull on to the next page, 1907 there, or the next page, I'm sorry, it says offering spread to swaps versus weighted average life.
Yes, I see that. That's a review of the PSE&G transaction. That's what this document is.
And it compares the Texas, New Jersey, and other deals, does it not?
Yes, it does.
And this is, okay, let's go on to the next page if we can as well. It says all-in spread to swaps versus weighted average life. You see that?
I see that.
And again, Texas deals, New Jersey deals, and other deals.
That's correct.
And this is the first page of this entire document that you have says RRB spread summary. I think that could also be stated as rate RBB spread summary, ratepayer back bond spread.
Ratepayer back bonds, yes, that's correct.
Right. And would you say this is a visualization of the types of the benefit, visualization of some of the benefits of the implementing best practices in ratepayer back bond transactions?
To a certain extent, it obviously is, and indicates how a utility can do better than the average under certain conditions.
All right, now, thank you so much. Now, in some of the questionings about flexibility earlier, it seemed to be suggesting that the company interest might in some way trump ratepayer or other interest as part of that statute. Obviously, in these bonds, these are not traditional company bonds, but are rather being paid back by the ratepayer. So you would think that the ratepayer interest would be considered as part of the flexibility, would you not?
I would say so, yes.
All right. Just making sure we covered all the points here.
And if there's one thing I may add to a discussion that Mr. Fischera had just a moment ago in response to a question on how these ratepayer-backed bonds and their incentives differ from traditional utility bond issuances, I would add to that for utilities that have rate settlement agreements that last a number of years, let's say 3 or 4 or 5 years, it is possible that if you have bond issuances during that period of time, which may not be totally reflected in rates, some of those costs may slip between the cracks. But that certainly does not happen with respect to ratepayer-backed bonds, where the total amount of the bonds is guaranteed for recovery. Just a point of clarification.
Very good. And I just have one other.
I just want to clarify something to Hyman. That presentation you have is more than just the PSE&G transaction. That was looking at, Mr. Schoenblum wasn't with Sabre Partners at that time. In 2005, I think that presentation was done and delivered to us by Barclays Bank. That looked at all New Jersey transactions for that time period versus all Texas transactions using a methodology similar to what was in Mr. Sutherland's testimony, regression analysis of credit spreads, to be able to compare benefits and costs. And notably, the New Jersey line is higher than the Texas line. New Jersey had a financial advisor, had certifications, but those certifications were not unqualified, were sort of circular. That was discussed in Florida in 2006, where they looked at certifications in determining best practices, and they determined the certification in New Jersey was not as good as the certification given by the advisor in Texas, and they incorporated the Texas version that Ms. Klein talked about in that financing order in 2006, which then carried over to the 2015 Duke Energy Florida transaction. So I just wanted to try to connect various dots here, so what you're seeing for the commission.
Mr. Shlum, I have sent you one more statute to take a look at, if you could. Chair Mitchell, I would like to bring up the first of the public staff's pre-marked redirect exhibits, pre-marked exhibit 35. Pre-marked exhibit 35, that's page 1789. A great year, by the way. Let's see here. Pre-marked exhibit 35, which is, again, the commission statute, the public staff statute, and the storm securitization. Just have one quick point on this. Mr. Shlum, do you have that?
I do.
Chair Mitchell, I would like to mark this as public staff redirect, public staff Shlum redirect exhibit 2.
Chair Mitchell, and I certainly don't have any objection to marking this, but it's also in the record as Heath, or public staff Heath cross-examination exhibit 1.
It is, and so in the interest of avoiding duplicate entries, Mr. Creech, I'll ask that you that we hold on your request and that your witness can refer to the document, but it is already in the record.
That's great, because that's actually the one I sent to him. So that's good, just as well. Mr. Shlum, and thank you for that, Mr. Jeffries. If you will, just on that document, it says at the top 16-2 declaration of policy. See that?
62-2.
I'm sorry, 62-2. That's right. Scroll over three more pages, if you will, to 62-15. And then scroll down to G.
G.
Certainly not trying to overstate the public staff's role here, but did want to go to G and at least get that noted in the record, if you will. Can you read that, please?
The paragraph beginning with upon request.
Please.
Upon request, the executive director shall employ the resources of the public staff to furnish to the commission, its members, or the attorney general such information and reports, or conduct such investigations and provide such other assistance as may be reasonably be required in order to supervise and control the public utilities of the state as may be necessary to carry out the laws providing for their regulation.
Thank you, Mr. Shlum. And I believe you had referenced the public staff statute before, but obviously that's just an additional role that the General Assembly has contemplated within the public staff. Is that correct?
That's correct.
I'm not certain that I have any other questions for you, Mr. Shlum. Let me just double check if I may, please. Shlum, thank you so much. I appreciate your time very much. Thank you. Witness Fischera?
Yes, sir.
First of all, I guess I will pull back up public staff redirected, Shlum redirected Exhibit 1. Was there anything else that based upon your discussion with Mr. Jeffries about best practices and the slide he had, is there anything else kind of about the visualization here on this Barclays Capital piece that you want to, that would give additional effect to what you were saying in that all the best practices cannot be put in a slide, but that there are quantifiable, demonstrable outcomes to this process?
Yes, and those were also over time. And I think when I interrupted a few minutes ago, it was also to point to Mr. Sutherland's testimony where there was a similar study like that done by Citigroup back in 2003, I believe, 2004, that looked at the credit spreads, because that's the only thing you can really affect is the spread over a benchmark. At that time, those were spreads over what is known as the swap rates for various maturities, as opposed to treasury rates. And by getting closer to the benchmark, that's your savings. So when you see spreads for different tranches, because you're going to have different maturities of bonds, they will have different spreads relative. There's a pattern that develops in those, and you can see. And sometimes some are higher than others, but that's what a regression analysis tries to smooth that out and say what trend lines are here. And that graph is another example of an analysis that was done by Barclays Bank and provided to us with permission to use with our clients. And there was also the study that was done of the Florida transaction, where you see the same thing looking at of the transactions from 2010 to 2016 and where the savings were. And, you know, it's an interesting graph because it also goes into the notion that at the shorter maturities, the Florida transaction was sort of like average, maybe even a little higher than some other transactions. But when you went out to the longer maturities, where there was much more expensive to the ratepayer, cost more, longer years, as Mr. Heller said, you know, 1 basis point over 2 years may not be a much, but 1 basis point over 20 years, a lot of money. And also the size, those were much lower. So we got lower interest rates. So this is sort of shows that when you implement various things, you can have a result, and it's been replicated. So it happened multiple times. So it wasn't that you just got lucky. Sometimes you get lucky. Other people, you can. Other times it's through hard work. Sometimes it's both. And sometimes it's both.
Go ahead.
I was quoting Napoleon, who said he preferred lucky generals to smart generals.
Right.
It is important to have this sort of process and look at then the certifications. That's what I wanted to point out. There were certifications in New Jersey, but the Florida Commission evaluated those in 2006. And I believe that somewhere in the record, the decision memorandum from the Florida Commission that was presented by staff as to what to require in the financing order about an independent certification without qualification. And they specifically spoke about New Jersey and versus Texas. And that goes to Mr. Jeffries about best practices. So New Jersey sort of had best practices. They had commission involvement. They had an independent advisor with Bear Stearns. They had a certification, but the implementation of that varied. And this was a quantitative way of doing it.
Okay, thank you. and a lot of the time, questioning of you in particular related to kind of the role of Saber's witness of clients at various times and commissions. And so I wanted to explore that with you just one more moment. I mean, it seems to me from what you were saying, and again, you can put it in your own words, but that isn't it true that whether it's a commission or public staff, there's kind of a basket of responsibilities in various states, and in some states in which you've worked, the commission takes on not a judicial type function, but also files testimony routinely and does a little bit more investigation in some states than other states. And it's just kind of the baskets are separated in different ways. But can you speak to that?
Yes. I mean, first of all, I separate the commissioners from the staff to the commission. So in every state we dealt with, the commissioners made the final decision. Staff never made a decision. The commissioners made the decision. The commissioners sometimes delegated to one of their commissioners to be a lead or to act through, but it was the commissioners deciding how it should be done. And that's the same as the public staff proposal here. The commissioners will be making the final decision as the structure, marketing, and pricing. Second was the staff. Who puts on testimony? I've learned a lot in this process, given back to the data requests and everything about, the distinction between public staff and commission staff in Florida. Public staff is called an intervener. Staff who put on testimony in Florida was not called an intervener, but it was just staff testimony. These sort of distinctions are a little bit beyond me. We just saw who is putting on testimony on behalf of the ratepayer for the commission to make a decision. And that's what we've seen. North Carolina is a little different than other states. And as I said, that statute that you were just reading about, that's the first time we've seen somebody other than the commission being specifically authorized. And then as we prepared for this case, looking more at the statutes that both you and others have had us read, we got more into the weeds here about your authorization and such. But from a big picture, we're just looking at who put on testimony for the ratepayer. In North Carolina, it's public staff. In Florida, it was commission staff. In Texas, it was commission staff, as well. In California just recently, commission staff didn't put on any testimony, but they did it a little differently in terms of setting up a finance team that didn't involve a repair, but just involved the commission staff. So I think this is a great country. There's a lot of diversity here. And as we work with the different states, we see that there's different roles of consumer advocates, and commissions handle things differently.
Right. And one of the questions that seems to have come up is just joint decision making and kind of running through that a bit. And you touched on, obviously, that the commission is the ultimate decider, and to be clear, obviously the commission decides, right? So
yes.
Let's say if the commission decides to be a so-called joint decision maker, or decides to has it been explored the scenario where if the commission decides for whatever reason to not be a joint decision maker, and potentially not the public staff either, what happens then? What happens then? Is that really a bond team scenario?
No, that's not really a bond team scenario. No, because that's basically the way it started out in 1997. It was just the companies took it and ran with it. I think, for example, maybe I shouldn't say that completely. In New Hampshire, I believe in 1999, they had the state treasurer get involved. It was a small in securitizations and bring the state treasurer actually in the process. So there was something, again, diversity of approaches. But starting in the 2000s, when there were more issues and people were realizing more and more about this, there was more desire to have a lowest cost standard, as we were talking about, having ratepayer representation and having independent certifications. So that's, Louisiana did that when storm securitization, Florida then did that. And it's being discussed now. I think if you see legislation that was passed last year in Colorado and in Montana have a role for the commission. However, if you go to New Mexico, you find that it's not there. The commission is basically left out. The politics in New Mexico are kind of different than everything. That's, again, great diversity in this country.
A lot was discussed in your the cross-examination of you about Florida, and you spoke to it as well. And I was hoping if we could, Chair Mitchell, to pull up pre-marked exhibit 69, which is public staff. Well, it's going to be pre-marked exhibit 69 on page 3246. It's from the Florida Public Service Commission for DEF, Duke Energy Florida. It's a transcript.
All right, Mr. Creech, let's go ahead and get the document marked.
Chair Mitchell, I would like to mark this as Public Staff Esera Redirect Exhibit 1. That's right. It's, to my knowledge, this has not been introduced before, and this
All
is
right.
my.
That's right. So we will name the document Public Staff Esera Redirect Examination Exhibit 1.
Mr. Fischera, can you please tell us what this document is, if you will, please?
I believe that's the transcript of the emergency meeting, it was called, after the structure, marketing, and pricing of the bonds for Duke Energy Florida, a project finance securitization, to consider whether or not to issue a stop order on the transaction. The same process that is being proposed here with public staff performing the role of commission staff there. And it is staff presenting to the commission why they believe that the commission does not need to stop the transaction, and it is allowed, and it is all other interveners like the large energy users, Office of People's Counsel, and the company themselves all got up and spoke and gave their views about the transaction and commented about the participants' role in the transaction and what saves ratepayers money and who did what.
Okay, and thank you, Mr. Fischera. And if you can, please turn over to the beginning of the.
I don't have the document right in front of me.
Okay, I'm sorry. I thought you were picking up there.
Well, I pretty much know about hard, but not the specific.
Well, that's fine.
Just let me. You sent that to me, right? Let me just pull it up.
I'll send you another copy here.
There's an excerpt, a video excerpt. By the way, the meeting was taped and is on the website of the commission, and also there's a 5-minute excerpt of the meeting with the transcript that's available on our website. Did you just send me that?
Yep, I've just sent that, and the video you referenced, the link to that is on the last page, but that is not technically part of the transcript. Is that correct? It's just an excerpt.
Yeah, that's not on the website, but the video is a full rendition of the transcript, the parts. As a matter of fact, every frame of the video shows the transcript part that the person is talking from.
Okay. And as that email comes through to you, one of the folks who is involved in this and who is referenced is a Miss Triplett, who I guess is or was an employee of Duke Energy Florida. Is that correct?
Yes.
Okay. And what I was hoping you could do, and let me know when that email comes through.
I have it now, Zeke, and I apologize to the commission for waiting. I'm sorry. What page? What page do you want me to go to?
It's actually you're all the way down on the PDF sent to you on page. Let's see here.
Look at the upper right-hand corner.
Yeah, that's right.
What
It's
page?
on page 13.
Page 13, right. Yes.
Right, I think you've highlighted some language there of Miss Triplett's, but is it? Let's have you read the highlighted portion there, if you will, please.
Yes. This fantastic outcome is no accident. As you pointed out, it is the culmination of months of hard work. And I actually went and looked at my calendar, and the first bond meeting was at the end of October, and I don't even think the financing order had been issued. So everyone hit the ground running. There were several weeks where we had multiple meetings, lots of emails, lots of review of documents, and I just wanted to highlight just a few things. We included this in our issuance advice letter that was filed today and circulated to the parties yesterday, but I think it's important to note that some of the good work that was done. Do you want me to continue reading?
I think that is that a good summation of what ultimately culminated in the Duke Energy Florida transaction that has been discussed so much today?
Yes. I mean, it talked about the company's work. I mean, she's talking about the company's work in it and highlighting that, obviously, as the company's representative. And we had no qualms with that. It was it was a fair and good negotiation that ultimately resulted in a good outcome. I think she mentions on page 15, I can read that. And as Mr. Maher noted, he was the staff member. We reviewed the opinion letter from Sabre Partners, and it does not contain any qualifications with respect to the opinions that he was giving in compliance with the financing order. So again, all signs point to no stop order. So yes, I think it shows the whole process there. The company didn't get everything it wanted. We didn't get everything we wanted. It was a negotiation, but it produced an outcome that Duke has now put in its application for DEC and DEP, which it didn't have in its application for DEF. So I think that's progress.
Thank you, Mr. Fitzgerald. You did reference the issues memorandum a moment ago from, I think, the 2006. Is that the FPL issues paper that you were speaking of?
Yes, that's the Florida Power and Light. That was the first storm securitization, and it is was modeled on the North Carolina law was modeled on that law.
Okay, Chair Mitchell, I would ask that that is public staff pre-marked 42. And Mr. Fisher, that's also in what you've received.
Right. What page of the PDF is that?
I'm showing you right now. It is PDF page 1966.
I don't have a PDF page of 1966. You gave me a 63-page document here.
Well, it's not the same then. My apologies.
As I'm scrolling through, these are,
all right. Let's see here. Here you go. Chair Mitchell, do you have that?
I do.
Okay. Chair Mitchell, I would like to mark this as public staff Esera redirect exhibit.
I think we're at 2.
2, that's right.
All right, the document will be marked public staff Esera redirect examination exhibit number 2.
Mr. Fisher, are you familiar with this?
Yeah, can you send me that?
Yeah, it should be there right now. And maybe we can just discuss it as.
Is it in the potential cross? Okay.
That's right, yeah.
I have all that. Those.
And I've emailed it to you. It's the Public Service Commission dated May 8th, 2006. It's the Florida Power and Light issues paper.
Yes. That's
it is my most recent email to you. But in the meantime, Mr. Fisher, you are familiar with that issues paper, are you not?
yes, and we can talk about it as we go through.
Well, I don't need to talk about it long. I just you referenced it, and I wanted to make clear what you were speaking of.
Yes, the issue paper discusses various things that to be. Yes, it just came in. It just came in. So, 19. What page again? 19. What?
66.
Yes, sir. So staff prepares, a summary of all of the issues and the positions of various people in the party, and then makes recommendations to the commission as to what to do. Yes, I have it now. And as you see, it's got this is from the public record. It's got the initials signed for the Division of Economic Regulation, General Counsel, Regulatory Compliance, various other people, to discuss what should go into the financing order for the first storm securitization in the country.
And you said that was served as a model including for North Carolina. Is that correct?
Yes.
Helped
the legislation for sure. It didn't have a lowest cost standard, but they did have the catch-all phrase about not inconsistent with the statute.
And in that instance, the financing order did include that requirement, did it not?
Yes, that the commission could add any conditions that it wished that were not inconsistent with the statute.
And in that instance, the financing order did include that lowest impact standard, did it not?
That is correct.
All right. I just wanted to touch on 2 other things I believe that you were asked about today. You were, again, the best practices, the slide there was there. Again, I didn't want you to be limited to anything that was on that slide. I mean, Mr. Jeffries was clear about what it represented, and I think you were too. Was there anything else you need to clarify on that? Is there anything not on that slide that, excuse me?
Well, I think Mr. Jeffries is trying to, again, make the implication that it was only the commission staff's should be the ones that would be implementing these things. Again, if different states have different approaches, it's the principle of ratepayer representation that we'd like to get across, and the decision-making standard and the independent verification, not a self-certification process. And there's no aspersions about the self-certification that they're violating the law or anything like that. It's just that they may view one thing, you want to view another. As Ms. Triplett from DEF said that she reviewed our opinion, and she agreed with that opinion. And that's where you want to come out. You want to have people who have differing perspectives coming to an agreement, and then having that being able to be verified independently. So, having a second opinion is always a good thing. And having the approach, I think, as one of the commissioners said yesterday about trust but verify, is what you're doing. It's not that I'm saying that your certification, you're lying. I'm just saying, I'll trust you, but I need to do my own. I need to do my own due diligence and my own homework. And I worked for a boss named Ace Greenberg at Bear Stearns, and again, he sent out a memo to us once that said, "We believe everybody's honest, but they're more honest if they watch them like a hawk." So and that's within my industry and in every industry. It's sort of like diligence and observation. Everybody comes together. No aspersions. Nobody's saying anything, but that it's best to have all these different views come together and presented to the decision maker, which would be the commission.
Thank you, Mr. Fischera. Chair Mitchell, I don't have any other questions at this time.
All right, just so I'm clear, that completes public staff's redirect of the panel.
Mr. Grantmeyer, I don't.
That is correct. We have no further redirect.
All right, thank you, Mr. Grantmeyer and Mr. Creech. All right, we will turn to questions from the commission, beginning with Commissioner Brown-Plant.
Chair Mitchell, I have no questions.
Okay, Commissioner Gray,
I have no questions.
Commissioner Clodfelter.
Thank you. I had quite a few, but Mr. Fischera very helpfully answered all of them on cross-examination. Thank you, Mr. Fischera. I have no more.
It's the Vulcan mind meld, Commissioner Clodfelter.
All right.
Telepathy works.
All right, Commissioner Duffley.
I too had my questions answered through cross-examination.
All right, Commissioner Hughes.
No questions here.
All right, and Commissioner McKissick.
Likewise, Mr. Fischera was excellent in addressing the questions I had before lunch today. So it probably saved us a half hour.
All right, glad to hear that. All right, make sure y'all are on mute. I'm getting some feedback. Mr. Fischera, you answered most of mine as well. I am going to ask you a few, and I'm going to ask you to do your best to just provide very succinct responses, since you've provided so much testimony already, and you have you've been very helpful with your answers. So,
thank you.
Can you do your best to just briefly describe for me the change in involvement that occurred from the 2005 or 2006 proceeding in Florida, the 2015 proceeding in Florida, the change in involvement of both the Florida PSC as well as the Florida Office of Public Counsel?
I don't think, 14 years ago, I mean, in that proceeding, it was a very contested proceeding, the first storm securitization. I know the Attorney General and other things were very much involved. Staff, we were hired by staff, didn't have any real interaction with the Office of People's Counsel at that time. And that financing order adopted pretty much all the best practices. However, it gave the option of the utility in the end, in communicating with the option to do a competitive bid. meaning that they did not do a negotiated transaction where we selected a group of underwriters and just negotiated with them with the roadshow and such. The company decided that it didn't want to do some of the things that staff wanted to do in a negotiated transaction, and made an offer that they would do a competitive bid, and that the competitive bid would, at least in their filings, would the rates on the competitive bid would meet or be lower than a Texas transaction done in 2005 and a West Virginia transaction in 2007 at the same time. And we were advisors to West. So Florida Power and Light said, we'll do a competitive bid, not a negotiated transaction with the bond team. And as long as the credit spreads are within that range of the Texas transaction, and there is no need for additional certifications. The competitive bid would satisfy it. And if the rates were higher than either the Texas transaction or the West Virginia transaction, shareholders would pick up the additional cost. And that was a very specific offer, unusual offer in 2007. So the commission accepted that offer, and they did a competitive bid, and they came out a little bit better than, a couple of basis points better than the West Virginia transaction and the Texas transaction. So now when we go to 2015 and 16 and start the process, we were hired by staff again, and gave testimony. And since at that time, we had also had gone through the SEC, got a no action letter about how to structure the bonds as corporate securities and not asset-backed securities. And we made that proposal to do a negotiated transaction, but with a corporate structure based on a 2007 SEC no action letter. So that went forward, and there was then rather than a contested hearing, we got a settlement, a joint stipulation through the process. And in that process, OPC and other interveners were agreeing about the amount of money that would be of the plant, the nuclear power plant for Duke Energy, Florida, that would be recovered in rates, and the length of time for the amortization period for that to be. However, the bond team, they then did a quasi public meetings. I think some of the bond team meetings were noticed. Some of them were public, where anybody could listen in on the calls, and some were just in an executive session. So it was a little bit of a hybrid from what was done elsewhere. I hope I'm not getting too into the weeds on this, Madam Chairman. Good. So it was a little bit of a hybrid, so that there was more transparency for these bond team meetings, so that some of the interveners, like the Office of Public Counsel, could listen in but not participate in anything. The transcript from that, I point you to the Office of Public Counsel's comments about what they saw the value of an independent advisor, specifically naming us in the process, how much we saved. But the staff was really directing it. We were, again, advisors, and it was done all on a consensus basis. And as you go through in this process, for example, I know there's been these sort of references about talking to the SEC, talking to investors. Once the bond team starts to meet, there are protocols. For example, once we meet and decide and file a document with the Securities and Exchange Commission, the protocol will be that no contact with the SEC would be done independently, but that it would be done through the company's counsel with commission or an advisor counsel involved. Like, so we'd have counsel involved in that, but nobody was talking directly. But that's the protocol. The same with the rating agencies. Once you submit something with the rating agencies, they'll go through they'll go through a process of running, and we sort of all agree about what we're going to say. We should all be speaking with one voice, things like that. Now, prior to that formal process, we'll have conversations. We may have conversations with the rating agencies or with the SEC. For example, in preparing for this hearing, last week, I contacted the SEC to make sure that there were no changes in their policies with regard to the structure that we did in 2016 and with the registration statement that was done in 16. Did not talk about this transaction because there is no transaction. It was just wanted to know from 2016 to now, have there been any changes? Why did I do that? Well, back in 2015, the company gave testimony with Morgan Stanley that this SEC no action letter that was gotten in 2007, which was obviously 8 years old at that point, was no longer valid. They actually put, I think in a response to a data request, they said that that no action letter was no longer valid. It didn't apply. And if we had to go back to the SEC to get permission, it would take a long time and we're not going to do it. Well, we, in terms of doing due diligence, determine, is that accurate? Did the SEC really change its mind? I was involved in the process in 2007. I talked with the SEC through counsel on that transaction and got that no action letter, which is a very formal process. And I didn't think it had changed, but they said it did. Maybe they're right. So I contacted the SEC and we found out that they were wrong. They hadn't changed, and that they said that their policy was that if they've given a no action letter and if it's on our website, on their website, it's still valid. It was on their website, it's still valid. We then informed that of the company. The company, sort of didn't believe it. Then we arranged a conference call with counsel with the SEC in order to get that clarification. They gave it, and then we were able to pursue that structure, which is called a series trust, that it's not an asset-backed security. Everything that Mr. Heath was talking about yesterday about making sure it's a corporate security and not being a structured product and none of that is tied to that 2007. And so we did our due diligence and spoke. Again, this week, I talked to the SEC. Anything changed? Nothing has changed. I also asked him about the disclosure because one of the things we did in 2016, Sabre Partners recommended that there be a question and answer section in the prospectus about the structure, about the legislation, about the true-up, and that there be, a frequently asked question with an answer. This is often done with salesmen, which pieces of paper, but those aren't part of the prospectus and you can't really circulate them. But if it's in the prospectus, then it can be circulated to everybody. So we proposed a question and answer. We got a lot of pushback from Duke. The lawyers said it's never been done before. We haven't seen anything in the SEC. You haven't seen any prospectus that has had a question and answer. And we think that that'll cause delays. It'll be a problem. We pushed back and said, well, look, why don't we try it? As long as, the rule is, as long as we're saying something truthful and honest and it's in the prospectus, the procedure is to submit the document to the SEC, wait for their comments, and then respond. So if they have a concern about it, they'll tell us. And if they have a concern and ask us to remove it, then we remove it, or we can talk to them about it. And that's it. They had no comment. So I also asked about that. And this person at the SEC said, oh, no, we like Q&As. The SEC itself often puts out its own regulations in a question and answer format because we find that that's more informative to the market of what the meaning of their rule or regulation is. So we wanted to apply that same principle in the Duke transaction in Florida, and we hope that Duke will do it again here. We have not seen, so we think for example, that we think that's a best practice. Let's use a Q&A. Let's make the offering document as plain English as possible. Stop the legalese. We want to get as many investors as we can. We want to even get the small investor. I was here, he said 5 million. I would like to get investors of 1 million or 50,000 in these AAA bonds. They're great bonds. And the broader it is, the better. So in 2016, we did more on the disclosure. We did more on the structure than we did in 2007. And it just shows the evolution of the market and how people with differing views can come together and we'll create a better product. Now, not everybody has adopted that. For example, Southern California Edison Company in California right now is doing a securitization. They just amended their registration statement from what they put in October to adopt to the Duke Energy Florida structure. Go to Wisconsin. Wisconsin is doing a securitization. They just filed a registration statement. It's not using that structure. It's a smaller deal, different. And so not always adapted. So somebody could point to Wisconsin and say, why don't we do it like Wisconsin? Somebody could say, well, why don't we do it like Florida? Somebody will say, why don't we do it like, Louisiana? So there's a lot going on here in this, and therefore you need to sort through that, and the commission needs to be able to sort through that because this is, as I said in my opening remarks, a unique use of the commission's authority to create this, direct payment on everybody's bill that you are going to agree to raise to whatever level is necessary to pay the bonds, with the state pledging that it's not, nobody else. And if somebody doesn't pay their bill, we take their loss and we redistribute it to everyone else. Nowhere else is a security like that. One time an investor asked me, really? You mean if people don't pay the bills, the people who are paying get their bills raised? I say, yeah. And they say, is that legal? I said, it's in the law. It is what it is. And that's why we think that these should price much closer to U.S. Treasury securities. They should be have much lower interest rates than Duke's outstanding first mortgage bonds, which are considered the highest quality bonds in the market. They got a AA2 rating, I think, on the first mortgage bond. Got to beat that and such. So from 2006, they did a competitive bid. They did some other things. Got a new, it was 2007. No action letter got in 2007 in West Virginia. Other people didn't adopt it. Then in 2015, we did adopt it, went through it, and now it's in Duke's application here. Great. And now we're just saying, what's the pre-issuance process to make sure that we are all on the same page, as Ms. Triplett said at the end, where this is a fantastic outcome, everybody's hard working. That's what you want. That's what you want to get. The same thing here for North Carolina. And what I think is most important is, as Ms. Klein pointed out yesterday, is you're really starting a program. Now, Duke when we said that this was a program, they asked us, what program are we referring to in my testimony? And I went back and said, look at the legislation, look at the legislative note. There's going to be multiple issuances. There's going to be more storms. You brought up the notion of a storm reserve, and it was good. There was an opening today that maybe you ought to have a funded storm reserve. That's what was done in Florida at these low interest rates, as opposed to the weighted average cost of capital. You're going to be coming back to the market. You want to have a good template so that your time, the next financing order, we won't have a full hearing. It can be more, just updating in case there's been any real developments that have occurred. that will be more efficient. We can get it almost like a shelf filing, and in North Carolina will have access to, to this market. The consumer groups will all see it as a positive thing, working together with Duke and with the commission and public staff. And as I think it was said by somebody, a high tide raises all boats. So that's that's the development from 2016. And it wasn't short, but it was detailed. And you said I could give you into the weeds.
All right, Mr. Fischera. Well, you sure covered a lot of ground there, but you answered my question. So I will let you go. I appreciate your response. And
I will say that sincerely.
I will check in with council to see if any questions on commission's questions.
Mr. Jeffries, go ahead.
Yeah, I don't think the company has any follow-up.
Okay, thanks, Mr. Jeffries.
And I just had, Mr. Fischera, if you can be very brief on this, very brief. I take from your comments just now that relating to the evolution and in Florida, that Sabre is somewhat agnostic in terms of whether it's involved with the commission or a public staff, or your role has been more just trying to get the best deal for the ratepayers. Is that correct?
Yes. Anyone who would like to follow best practices, even if the utility wanted to follow best practices, we'd help them out too. I mean, I think the approach is there are certain things here that have worked and should be replicated.
And then finally, you mentioned some of the ones, if the commission decides there should be a bond team here and whomever's on it, whether all that, it is the case that guardrails are effectively put in place, and that while certain communication with the SEC and rating agencies will certainly be put in place, it's your view that the due diligence that an advisor like yourself should do within those guardrails should not be limited. Is that correct?
Yeah, I mean, we all know certain rules and principles. For example, when we talk with an investor, we do not talk, and there's a registration statement on file. You can only talk from that perspective if they have any questions about that deal. We just know that. But if you talk to the investor, if the investor wants to know something about the commission or about the financing order, which is described in the prospectus, and I think in my testimony, I talk about what I talk to investors about. And I think Mr. Moore today talked about how we want to get market intelligence and get people's views and see what they're thinking and what they're hearing and what the underwriters are saying to them versus what the underwriters might be saying to us. Again, we're not trying to impugn anybody in terms of it. I've been an underwriter, and I've seen that sometimes things get distorted, or there's different approaches, different things said with different emphasis. As Brian Maher mentioned, every time he talked to underwriters, they said it was the rate was going to be X, and then after he did some more due diligence and talking to different banks, suddenly it was X minus something that he ultimately got. So that's the kind of process. Trust but verify. We believe everybody's honest, but they're more honest if you watch them like a hawk. And, we sort of think that the role that we're sort of performing is like the parents who, when you come home early if on a weekend, just sort of, like, what are you doing here, Dad? And the underwriters are like, well, what did you say here? I was just looking around. What are all these chairs? What's that? It's really the underwriters who are on the other side of the table. Duke and the commission and the advisor are negotiating with those folks. And so that we can have a united front with them, just like what was done in Florida. I think Mr. Schoenblum said, don't tinker with success.
Thank you, Mr. Chair. Thank you, Chair.
All right. Well, with that, we have come to the end of this panel's time. Mr. Mr. Creech, Mr. Grantmeyer, I'll entertain motions at this point.
This is Mr. Grantmeyer. I would move into evidence the mayor testimony and his 5 exhibits, and also the Moore testimony, unless it's already been admitted into evidence. He had no exhibits.
All right, the Moore testimony is in, but hearing no objection to your motion, I will allow the evidence to Mr. Maher's testimony to be admitted into evidence. All right, Mr. Creech.
Yes, Chair Mitchell, I would like to place into the record Mr. Witness Shlum's testimony and 2 exhibits, and then Mr. Fischera's testimony and 6 exhibits, and certainly their summaries and the summaries of the witnesses who I believe they were read in, so perhaps we don't have to do that of the other 2 witnesses whom Mr. Grantmeyer just mentioned.
All right, Mr. Creech, hearing no objection to your motion, the exhibits of witness Schoenblum and Fischera's testimony will be admitted into evidence. Summaries for each of the 4 panelists will be admitted into evidence as well. Mr. Jeffries, did you have something to add?
Yes, Chair Mitchell, we would move that DCDP Fischera cross-examination 1 be moved into evidence.
All right, so motion is allowed.
Madam Chair, the public staff would also move that the public staff's redirect exhibits be entered into evidence. I believe it was 1, 2, and 3.
Have Schumblum public staff Schumblum redirect exhibit 1, and we have public staff Fischera redirect exhibits 1 and 2.
All right. All right, for purposes of the record, hearing no objection to the motion Mr. Creech has made, I will allow public staff Schoenblum redirect examination exhibit number 1 into evidence, and I will allow public staff Fischera redirect examination exhibit number 1 and public staff Fischera redirect examination exhibit number 2 into evidence. All right.
The public staff would request that Mr. Schoenblum be excused. He has religious observances coming up within an hour or so.
All right, that motion will be allowed. Thank you very much, Mr. Schoenblum, for your time today.
And based upon prior discussions with company counsel, I believe that the company is agreeable also to Mr. Moore also being excused at least by 4 o'clock today.
All right, hearing no objection from Mr. Jeffries, we will allow your witness to be excused as well, Mr. Creech.
Thank you. Thank you.
All right, with that, public staff, you may call your next witness.
Public staff would call Michael Manis and Michelle Boswell.
All right, let's see, there's Mr. Manis, there's Ms. Boswell. Would you all please raise your right hands? Do you affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right, you may proceed, Mr. Grantmeyer.
Mr. Manis, will you please state your name and your position with the public staff?
As Michael C. Manis, I am Director of the Accounting Division of the Public Staff.
And Ms. Boswell, could you please state your name and position with the public staff?
I'm Michelle M. Boswell. I am the accounting manager over the electric section of the public staff.
And to whoever wants to answer this, did you jointly pre-file in this case testimony consisting of 29 pages, appendixes A and B, which is your bios or background, and 2 exhibits?
We did.
And if I were to ask you those same questions today, would your answers be the same? I realize there has been a stipulation, so and you will address that, I'm sure. But would your answers have been the same at the time you filed this testimony?
Yes, we filed errata and a set of corrected testimony, so it would be the same as set forth in the corrected testimony filed.
Do you remember the date you filed the corrective testimony?
Let me chime in here if I may. I believe Mr. Grantmeyer was on January 6th and on January 13th. It was revised. It was corrected on January 6th and further revised on January 13th.
And if we were to ask you those same questions today on your January 6th and 13th testimony, would your answers be the same?
Yes.
I would request that their testimony be copied into the record as if given orally, and that the two exhibits be identified.
All right, hearing no objection, the testimony of the witnesses as has been corrected will be copied into the record as if given orally from the stand. The exhibits to that testimony will be identified as they were when they were pre-filed.
Mr. Boswell, Ms. Boswell, or Mr. Manis, will one of you please give a summary of your testimony? I believe you have an updated summary because there's been a stipulation.
Yes. The purpose of our testimony is to present the public staff's position on certain matters related to docket number E-7 sub 1243 and docket number E-2 sub 1262, the joint petition for financing orders filed with the Commission by Duke Energy Carolinas LLC or DEC and Duke Energy Progress LLC or DEP. In our testimony, we addressed 5 basic topics. 1, statutory basis for the petition and specific relevance to our testimony. 2, relevant general rate case proceedings. 3, cost to be securitized. 4, conditions of the general rate case stipulations affecting test of quantifiable benefits. And 5, application of the net benefit test. The petition was filed with the Commission pursuant to NC General Statute 62-172, financing for certain storm recovery costs, and includes the 2018 and 2019 storms originally proposed by the companies for deferral and amortization in each company's last general rate case, and subsequently removed from O&M and capital cost as part of stipulations with the public staff in each case. Additionally, the companies have included in the amounts to be securitized upfront and ongoing financing cost, servicing fees, and other costs related to the securitization of storm costs as provided for in the statute. The public staff has made several recommendations regarding the accounting for all of the costs proposed by the companies for inclusion in the securitization filing, including 1, provisions if the stipulations are not accepted by the Commission in each company's general rate case proceedings currently pending before the Commission, and 2, provisions to limit amounts charged to ratepayers to actual and reasonable storm recovery cost and financing cost. Furthermore, our testimony details the conditions of each company's general rate case stipulations that affected the test of quantifiable benefits, as well as the application of the net benefit test. We agreed that in the present case, securitization does provide quantifiable benefits to the ratepayers. The companies and the public staff have entered into an agreement and stipulation of partial settlement, which settles all accounting issues discussed in our testimony. This concludes our summary.
All right, are the witnesses available for cross-examination at this time?
The witnesses are available for cross-examination.
I'm sorry, I was on mute.
That's all right. That's okay. All right. My notes indicate that neither Duke nor the SICR have crossed for the witnesses, but I will ask counsel.
Yeah, I'm sorry. Go ahead.
I will ask counsel to confirm. Mr. Robinson, seems like you might be ready to ask some questions.
Sure, Chair Mitchell, I think I'll take a lesson out of Mr. Grantmeyer's book and ask one very brief question to the panel.
All right, you may proceed.
Thank you. Mr. Manis and Ms. Boswell, good afternoon. You would agree with me, would you not, that the stipulation that was entered into with the companies and the public staff was as a result of discovery and extensive negotiations between the two parties?
Yes.
Thank you. No further questions.
And Chair Mitchell, this is Christina Kress with SIGFR. We do not have questions for this panel. Thank you.
All right, Mr. Grant Maher, Mr. Creech, any redirect for your witnesses?
No.
Okay. Questions from the commissioners, beginning with Brown Bland.
No questions.
All right. Commissioner Gray?
No questions.
All right. Commissioner Clodfelter? Okay, no questions from Clodfelter. Commissioner Duffley?
No questions.
All right. Commissioner Hughes?
No questions.
And Commissioner McKissick?
No questions.
All right. Well, lest y'all think you all were going to get off easy, I have a few questions for you. I will go ahead and start with my questions. We're going to take a break at about 3:45 for the court reporter. So I'll ask you a few now, and if we don't get through them, we'll come back and resume after the break. First one is from our staff, and I'm going to read it. I apologize, but I want to make sure I get it correct. I capture exactly what they need from you all. Andrews Exhibit 1, page 1 of 1, provides the true-up mechanism form, which is the process to be used to ensure the recovery from customers of sufficient revenues to provide for the timely payment of the storm recovery bonds and their ongoing financing costs. The form provides the calculation of the average retail storm recovery charge per kWh to be charged to the company's customers on their monthly bills for the next projected remittance period. Witness Angers explains in her direct testimony the components of the true-up mechanism form and how it will be used as proposed by the companies. Would you all please explain how each component of the true-up mechanism form will now be calculated as a result of the agreement and stipulation of partial settlement that the company and the public staff have entered into? And please include in your response the frequency of adjustment on the form to the amounts included on lines 17 and 31 and lines 18 and 32, which are, just for your reference, the servicing costs and other ongoing costs. If this is something that you all would rather provide as a late filed exhibit, you may do so, but you may know off the top of your heads how to answer. So I'll let you respond.
I think it would be preferable if we did maybe provide this as a late filed exhibit. We have been engaging in some discussions with the company about the form, not necessarily related to the settlement. I don't know that the settlement in itself will affect the form, but we would be glad to provide whatever and probably do that in conjunction with the company if permissible to the commission and commission staff as to what the form would look like.
Yeah, please do work together and provide that information to us as quickly as you can.
Chair Mitchell, if I could just maybe interject with that. So I know that recently, earlier today, you provided us with late filed exhibit 1 that I think is relatively similar to that question. So what we will propose to do is to work in conjunction with the public staff and maybe have that, if possible, a joint late filed exhibit. Would that be appropriate?
Yes, that would be appropriate. And again, as quickly as you all can get that into us would be appreciated. All right. Question about the timing of the rate case order, where the prudency of the costs obviously is an issue. Does the public staff agree with the company's position that the companies can't proceed with the securitization until the rate case orders are issued?
Yes.
Okay. We are still waiting on a response from the public staff to the company's motion for an extension of or waiver of the 135-day period. So one of the reasons for my question. Mr. Creech.
Chair Mitchell, that has been a point of discussion within the public staff and with counsel to the company, certainly this morning, while the public staff has some concerns about delay, including the whether we can actually meet that time frame, and also, the issuance time frame, and sufficiently market within a truncated period of time. We've kind of shared that concern in another one with the company, and the company's receptive to hearing from us. And so the public staff does not object to that proposed temporary waiver, or the right terminology. And I do appreciate your patience in hearing from the public staff on that. And I also appreciate the company hearing from us on that as well.
All right, thank you, Mr. Creech. Okay, so Mr. Manis, just back to you. I want to make sure I heard your answer. You indicated you do agree, the public staff does agree that the company needs a final order in the rate cases before it can proceed with securitization.
Yes, we do.
If it's possible. Okay. Okay. All right. A question for you all that follows up on a question that I asked of company witness Abernathy. I'm not sure if you all heard her response, but my question pertains to the accrual of the carrying charge, which is calculated at the company's weighted average cost of capital. My understanding, or our understanding of the testimonies filed, is that the carrying charges accrue at the 2017 rate until the 2019 rate becomes effective. That is the rate that is presently pending before the commission in those 2019 rate cases. We heard witness Abernathy today state that the companies have put the interim since the interim rates are into effect, they are using that interim weighted average cost of capital. Is that the public staff's understanding as well? And do you agree with the company's position on this issue?
Yes, we do.
Okay. Yes to both questions?
Yes.
Okay. Okay. All right. Will you all, either one of you or both of you all, talk us through the how the audit is going to work going forward of the ongoing costs associated with this with the financing? Can you, we've heard from witness Abernathy that the understanding is that it's a scope that's more limited in scope than a prudence review, but I'd like to hear from you all on that now. And so just generally talk us through the process.
Well, procedurally, we've agreed in the stipulation to provide the company with the data request by March the 5th. And then they will hopefully provide fairly quickly a response. And then we will proceed with discovery and have agreed to file something with the commission within 60 days. Are you referring to the audit of the storm costs, or you were talking about?
Well, no. So you're talking about the update to the storm costs. I do. Since you've mentioned that, Mr. Manis, I do have a question though. Do you all anticipate that you'll have sufficient time to reflect any adjustments necessary in the final amount to be securitized?
I think our expectation is that there won't be any unexpected disagreements between the company. We just have to complete our due diligence.
Understood. There. Okay, thank you for that clarification.
And I apologize, you were probably talking about the ongoing financing costs. And
I was. So just help us understand, talk us through the process of how the audit will occur on those ongoing costs.
The company basically, I believe each month will provide us with explanations, invoices, and other documentation for the ongoing financing costs. We're basically looking for any major differences between what the expectations are for those costs. The company, I believe in Mr. Heath's testimony, has provided an exhibit detailing those ongoing financing costs, and you estimate a sort of a range of estimated amounts for each different type. We will be taking a look at those and, of course, looking for mathematical and clerical errors in the true-up calculation itself, but also looking at the costs themselves and see if they are basically consistent with what's set forth in the stipulation.
Okay. And can you help us understand why the decision to do less than a full prudency review was, I'll just leave my question there. Why less than a full prudency review?
That was essentially a compromise between the company and the public staff. Looking at it from the public staff's perspective, we're interested in protecting the ratepayers to the greatest extent possible. However, there are certain requirements and limitations within the statute with regard to the review of true-up amounts. And so in discussing those various concerns back and forth and limitations, this was just where the parties landed as a reasonable compromise. We think that it's sufficient to provide protection for the ratepayers, and it is a standard with which the company has agreed to allow us to review.
All right. Thank you, Mr. Manis. All right. Let me just go through my notes to make sure I've covered. All right, that is all from me. I will check in now with council to see if you all have questions on any of the questions asked.
Chair Mitchell, I just have a few questions.
All right, you may proceed.
Thank you. So Mr. Manis and Ms. Boswell, you recall testimony or questions from Chair Mitchell regarding the company's application of the weighted average cost of capital?
Yes.
And you are familiar with Ms. Abernathy's direct, I'm sorry. Did you say something, Ms. Boswell?
No.
Okay. Mr. Manis and Ms. Boswell, you are familiar with Ms. Abernathy's direct testimony in this case, correct?
Yes.
And Mr. Manis or Ms. Boswell, I don't know if you have it handy, but would you agree with me if you do that on pages 14 to 15 of her direct testimony, she discusses how the company's proposed to treat carrying charges on the storm recovery costs?
And give us a second, we can pull it up.
She does.
Ms. Boswell, you said she does?
Yes.
And Ms. Boswell, you agree with the treatment that Ms. Abernathy discusses on those 2 pages as to how the company ended up treating and factoring in those weighted average cost of capitals?
We did.
And last question, if I were to bring witness Abernathy back on the stand to describe what is on those 2 pages, you would generally agree with that testimony?
We would.
No further questions, thanks.
The public staff does not have any questions.
All right, Ms. Kruss, I assume no questions from you.
No questions. Thank you, Chair Mitchell.
Okay. All right. With that, I'll entertain motions. Grant Maher. Grant Maher, you may be on mute. Your turn to speak.
The public staff moves that their pre-filed testimony, their errata testimony, and their corrective testimony, and the 2 exhibits attached to their pre-filed direct testimony be admitted into evidence.
All right, hearing no objection, the motion is allowed. All right, at this time, Mr. Manis and Ms. Boswell, you may step down and be excused. Thank you very much for your participation today.
Thank you.
Thank you.
All right, with that, Mr. Grant Maher and Mr. Creech, do you intend to call any additional witnesses?
Chair Mitchell, we do have witness Abramson available. We were going to have him read his summary and have him available. I'm not certain that the company has any cross for him. They've not indicated as much. I don't know if the company, if the commission has any questions for him.
Well, let me, Mr. Robinson, confirm that you all don't have any cross for the witness at this point in time, please.
Chair Mitchell, I believe that's the case. That is Jim Jeffries, at least identified witness, so I'll let Mr. Jeffries just confirm that.
That's correct. We have no cross, Chair Mitchell.
All right. Thanks, Mr. Jeffries. Does any commissioner have a question for the witness? All right, Mr. Creech, Mr. Grantmeyer, it doesn't appear that any commissioner has a question for the witness. So at this point in time, you could move testimony into, make a motion regarding moving testimony in.
Yes, thank you so much, Chair Mitchell. Witness Abramson filed in this docket on December 21st, 2020, direct testimony consisting of 24 pages and 4 exhibits. And I would like to move that Mr. Abramson's pre-filed direct testimony be copied into the record as if given orally from the stand, and that his 4 exhibits be marked for identification as pre-marked in the filing. I would like to seek how we can also get his summary into the record as well, whether he needs to read it or I know y'all have the commission has a copy and the company has a copy, but I think it's a very good summary.
All right, Mr. Creech, if without any objection, we would allow you to move the summary in to evidence.
No objection, Chair Mitchell.
Okay.
Thank you, Chair Mitchell. So I'd like to move that his pre-filed direct testimony, 4 exhibits and summary be moved into the record, please.
All right, hearing no objection, Mr. Creech, the pre-filed testimony of Mr. Abramson, consisting of 24 pages, will be copied in the record as if delivered orally from the stand. The exhibits to that testimony will be identified as they were when pre-filed, and they will be admitted into evidence. Additionally, the summary of the testimony that the witness has prepared and that has been provided to the commission and to the parties will as well be admitted into evidence.
Thank you.
All right, and with that, the witness may be excused.
Chair Mitchell, this is Bill Grantmeyer again. The public staff would move that the testimony of Calvin C. Craig be entered into the record as if given orally. It's 10 pages and it was filed on December 21st. It has no exhibits, but we would ask that it be copied into the record as if given orally. Mr. Craig was the one witness we had excused.
All right, Mr. Grantmeyer, hearing no objection to that motion, the testimony of public staff witness Craig, pre-filed on December 21st, 2020, consisting of 10 pages, will be copied into the record as if delivered orally from the stand. All right, any additional procedural matters from the public staff?
Grantmeyer has none.
Okay, thank you, Mr. Grantmeyer. Mr. Creech, all right.
No, Chairman.
All right, with that's my understanding. Mr. Robinson, you'd like to recall your witness Heath?
Yes, Chair Mitchell, at the risk of causing ire to the parties on a Friday afternoon, we do have a few brief questions, redirect questions for both Ms. Abernathy and Mr. Heath. At this time, we would like to recall Ms. Abernathy first. I will be handling Ms. Abernathy, and then we will recall Mr. Heath, and Mr. Jeffries will be handling Mr. Heath.
All right, please do so.
Thank you. Ms. Abernathy, at this time, we'd like to recall you, Ms. Abernathy. Are you there?
I see Ms. Abernathy, and Ms. Abernathy, I'll just remind you that you are under oath. Okay.
Ms. Abernathy, welcome back. Do you recall a series of questions from Chair Mitchell asking you to explain the points in time when the differing weighted average cost of capitals are applied to the company's storm costs at issue in this case?
Yes, I do.
Ms. Abernathy, is there anything you would want to add or to clarify to your prior response?
I would just like to clarify my response to walk through the timeline of when we will change the weighted average cost of capital. So we will update the weighted average cost of capital in the carrying cost calculation for the storm cost after we receive an order in the pending rate cases and we actually have a new authorized return. In my testimony and in my exhibits in the calculations, specifically in, I believe it's exhibit 2 for each company in my direct testimony, at the time, we estimated that date to be January for DEC and February 1st for DEP. So those dates will be updated once we get final orders, and then the actual carrying cost will be calculated using the actual cost of capital to the extent that the assumption changes. Similarly, we will also update that calculation to go all the way through the actual bond issuance date, and the final amounts will be included in the IAL process.
Thank you, Ms. Abernathy. No further questions.
Public staff has no cross-examination.
All right. Any questions from the commissioners for this witness? All right, Ms. Abernathy. Mr. Jeffries, did you want to say something?
No, I'm sorry. I'm being over anxious.
Okay. All right. Well, Ms. Abernathy, you may step down. Thank you very much.
Thank you, Chair Mitchell.
And of course, at this time, Chair Mitchell, we would now officially seek to excuse Ms. Abernathy.
And your witness may be excused. All right, Mr. Jeffries, I see you're ready to go again, but I'm gonna give our court reporter a break. We will take a 10-minute recess. We'll come back on. We'll finish up the hearing and call it a day. So let's go off the record now, and we will be back on at about 3:55. All right, Joanne, before we go back on, just give me the, okay, perfect. All right, let's go back on the record, please. Mr. Jeffries, you are up.
Thank you, Chair Mitchell. Duke would recall Mr. Tom Heath to the stand, please.
All right, Mr. Heath, I'll just remind you, you are under oath.
I understand. Thank you.
So Mr. Heath, you and I are the two people that are keeping all these folks from a weekend. So we're gonna try to go quickly here, okay?
Yeah, completely understand.
Throwing rocks. So I've got about 4 questions for you, real quick. Do you recall when I was speaking with Mr. Fischera, we were having a discussion about Saber's, I guess I would characterize it as business interests in the ongoing bond transactions. And I asked him a question, or maybe he gave an answer that I was confused about, because I understood him, at least initially, to say that their expenses would not be included in any of the bond costs here. Could you tell me what your understanding is about how those expenses are being handled?
Yes, and I was a bit confused by that initial answer too. I do think Mr. Fischera may have came back later and somewhat clarified, but just to make the record perfectly clear, we are planning to include the fees from the public staff consultants and any legal counsel that they were to have, as well as any consultants and any legal counsel that the commission were to hire as bond fees, and they would be included in the upfront issuance cost and recovered in the issuance of these bonds. And so there's some discussion in my direct testimony on I believe it's pages 24 and 25. And then it's also in my Heath Exhibit 1 in my direct testimony that covers and lists out those estimated fees. So I just want to kind of note, as I think I said yesterday, may have said yesterday, the fact that the securitization statute mentions that any counsel and consultants that the public staff were to hire would be recovered in the transaction, treated as a financing cost. I don't think that breaks new ground in the treatment of consultants' expenses on behalf of the public staff, right? The public staff, the statute that enables the public staff already provides for the recovery of their outside consultants and experts transaction fees or fees, period, from the companies and from customers ultimately. And so that language in the statute is really enabling those fees, those expenses to be recovered in the bond issuance amount.
Thank you, Mr. Heath. Did you hear Mr. Fischera's discussion with Chair Mitchell in response to her question about sort of what are the differences between the 2005 and 2015 Florida securitization transactions, and particularly his comments about communications with the SEC and investors?
I did.
Do you have a reaction to that? As a be responsible for issuing these bonds as a company?
I do have a reaction to that. I heard that, and it immediately brought concerns to my mind. So we talked about this a little bit yesterday, and I'll elaborate more here. That when a party is thinking about, and I guess I'll preface my comment as Mr. Fischera did mention that his conversations with the SEC earlier this week, I think it was, were not about this transaction in particular. So I've got no reason to question that. But the fact that someone other than the issuers and underwriters would be permitted to speak to the SEC, rating agencies, and investors is very concerning to me. So parties that have no securities law risk or contract law risk being permitted to have those discussions is very concerning and problematic in my mind. There's a notion of entanglement. And so it's when someone speaks about a transaction, even if they're in sort of a quasi-official position, and then they're not the issuer, that anything they say can be attributed to the issuer itself, and that can increase exposure to securities law liabilities for the issuer. And so that's kind of that raised my, I said, not in context of the transaction, but they just brought those concerns fresh to my mind again.
Thank you, Mr. Heath. Those are two specific issues I wanted to ask you about. Now I want to ask you, my last two questions are more general. And I'd like, you've heard the testimony that's come into the record since you testified yesterday, correct? I just wanted to ask you what your reaction to that testimony was.
I was a bit confused today. Right? There's a lot of testimony both yesterday and today, and when I heard the public staff testimony today, I really got confused about what exactly are they proposing in terms of a bond team. And there seemed to be, joint decision-making, questions, and ultimate resolution of things by the commission, and a lot of different things. And to me, I almost am more confused sitting here now after hearing all of that testimony than I was before this hearing began. And so I would like to just kind of come back and just present the bond team concept that the company has laid out, and just be clear about what we're envisioning there, what we've offered, and why we believe that is a very reasonable proposition if the commission were to choose to implement a bond team. And so what we've proposed is that a company representative and a representative of a designated commissioner or representative of the commission staff be the joint decision makers in all aspects of the structuring, marketing, and pricing of these proposed bonds. And that other members, be it the underwriters, be it the public staff, or any consultants that are employed by them or others, would be contributing members to the discussion and contributing to the development of all of the materials related to this transaction, including the registration statement, the rating agency materials, and the investor roadshow materials. And that, but those two decision makers, again, the company rep and the designated commissioner or member of commission staff, would ultimately decide what materials are put forth in consultation with their own legal counsel. And so I just want to be clear with that, right? So we're not in any way trying to limit the involvement of the commission in the issuance of these bonds. We're not in any way trying to shut the door on the public staff's involvement in this offering going forward as well. We believe there's places for both of them. I've outlined those, I think, at length yesterday. And to this question as why it might be appropriate for the commission to be involved, but not the public staff as that joint decision-making body. I'll go back to the things I said yesterday, and that is the commission and not the public staff has an obligation to make findings of fact in this proceeding. The commission and not the public staff has the responsibility of enabling the creation of the property right and the transferal of that property right to the issuing SPE. And the commission, not the public staff, has responsibilities to enact the true-up mechanism to ensure that the servicers, which will be the companies, are collecting enough cash and only enough cash to pay the principal, interest, and fees related to these bonds over time. And it's, again, the commission, not the public staff, that is making a state pledge or making a pledge on behalf of the state to not impair that property right and to not disallow charges going forward. So I hope that helps to clarify things. And again, I believe we put forth a very reasonable proposal here. I think I heard a couple of times mentioned today too, references, or multiple times mentioned today, to our 2016 DEF transaction. One that was involved in that transaction, certainly the FPSC staff, the commission itself, the underwriters, everyone believes that that was a very successful transaction. And I believe what we have laid out in our petition in this proceeding is a transaction that is very much like the transaction that was such a success in Florida, and it includes very many of the best practices
All right, Mr. Jeffries, lost your witness.
Yeah, well, there he is.
Hey, I'm sorry about that. So I think where I...
Mr. Heath, we lost you when you were saying it includes very many of the same best practices as were included in the Florida transaction.
Mm-hmm. And that's really what my final thought on that was, that we've included the best practices that we believe are relevant under the statute and relevant based on North Carolina regulatory practices, and the ones that have not been baked in are there or not there for those reasons.
And finally, Mr. Heath, is the arrangement that the approach to the bond issuance in this case, in the event that the commission does want there to be a ratepayer advocate involved in the issue?
Yes, it is. That construct of a bond team, if the commission were to decide that a bond team is necessary. Yes.
That's all the questions I have for Mr. Heath, Chairman Mitchell.
All right, I'll see if commissioners have questions for the witness. Commissioner Brown-Bland? You could just shake your head no. All right,
No.
Commissioner Gray? All right, Clodfelter, I see Clodfelter as a no. Duffley?
Sorry, I have one question. It's just a clarification semantics question. So, Mr. Heath, would the public staff under your scenario would not be a part of the bond team, but an observer, like in the room, but not part of the bond team? Or do you view them as being part of the bond team, but not a final decision maker?
Not a final decision maker. So I see them, along with underwriters, providing advice and recommendations and reviewing all the materials. Again, for the registration statement itself, the rating agency materials, the investor materials, reviewing and contributing to the development of all of those materials. But ultimately, what gets put forth in front of all of those bodies is determined by the two decision makers, and those decision makers being the company representative and a designated commissioner or member of commission staff advised by their counsel. So, whether the technical bond team encompasses all of those people, or, if it's the company advisor, the company and its advisors and legal counsel, and the commission and its advisor and legal counsel, that I think to me does get into semantics. But the point that I want to make sure we stress is that decision makers are strictly the company rep and the commission rep. Everyone else is contributing input, but it's those two folks who, based on all of that input and feedback they receive, that ultimately make the decision of how to go forward with the offering.
Okay, thank you.
All right, Commissioner Hughes.
Just a quick follow-up on that. Have you participated in this type of bond team for another issue, maybe not a securitization issue, where the company and the commission had joint public issue responsibility, and what happens if they disagree?
The only other transaction that Duke has participated in where there was any sort of bond team where we shared decision-making authority with anyone on a debt or an equity offering was the 2016 Duke Energy Florida transaction. And so there was a dispute resolution process in there where if there were conflicts between the joint decision makers that could not be resolved, there was a designated commissioner. So in there, the commission staff person and its advisor with the company were the joint decision makers. So if there were conflicts between those, a designated commissioner was available to resolve that conflict and say, here's what we're going to do. What I would envision here, if it's a designated commissioner as a joint decision maker, is that the full commission would decide how to resolve that dispute. Now, in Florida, we had no dispute that rose to that level that ever had to be resolved in that manner. We were always able to work those things out amongst the joint decision makers.
Okay, thanks for that explanation. No further questions.
All right, Commissioner McKissick.
Yes, Madam Chair, just have a couple of quick questions. Mr. Heath, in terms of the bond team as you envision it, would they have joint decision-making authority? You know, the person from the Utilities Commission and somebody from Duke dealing with the selection of underwriters. Underwriters fall in that category. They're making joint decisions over.
Sure. Yes, I do.
How about legal counsel? All right. And about the structure of the bond issue and if there's going to be in different tranches and the benchmark securities, pricing of the bonds. How about there? Do they also have decision-making authority?
Absolutely.
So the whole marketing plan gets incorporated into that same category of things where joint decision-making occurs. Is that right?
Yes, sir. Yes, sir.
All right. So are there any areas that are different in North Carolina in contrast to what was done in Florida, where North Carolina would somehow be unique in terms of the decision-making authority the bond team would possess in terms of its authority?
I don't think so. I mean, there are certain things. If there's a matter that Duke, the company, or DC, DEP, were to believe added to securities law liability, then we would reserve. We do propose that we reserve discretion to have unilateral decisions around those things. And we had that in Florida too, so that's not a difference to how the bond team worked in Florida.
Okay. And Mr. Fuchera, during his testimony, indicated that the two of you traveled together, I take it, to meet with potential investors and did that quite substantially. I take that was back in the 2016 period. Is that correct?
That's right.
And did you two accompany each other to virtually all of those investor meetings, or what percentage of them, and how did they go?
100% of those meetings, to my recollection. So we went to 4 or 5 different cities on a physical roadshow and met with multiple groups of investors in each of those cities. We had a large group investor meeting in, I think it was in New York, over a lunch session where we had 10 or 15 different investors come in and we all spoke to them about the transaction. We also had telephonic discussions one-on-one with investors. And I think we had a recorded kind of message as well that investors could call and listen to. So we participated in all of that together. I think those conversations were fine. And we had, we had it was myself, Mr. Fischera, representative from both of the underwriters, and on most of those discussions, it was actually a person from the FPSC staff as well who was in the room. And so we had, a book of, if I'm my recollection, maybe 15 slides or so, and we each had specific things we were covering. And the discussion from the FPSC staff and from Mr. Fischera were around things that the state is involved in through this pledge. So the pledge that's out that the commission is making here on behalf of the state, the true up mechanism, this property right, some discussion about the financing order itself. So our discussion, things I talked about were the Duke as the offerer or as the issuer, and the securities more broadly, and they were talking about things that the commission had more direct oversight and responsibility for.
Okay, and did you encounter any challenges or problems during the course of those meetings that were held? I mean, is there any that emerged that we might that might be addressed differently if we were to go in a similar path in terms of perhaps bringing in a financial advisor to help the commission? What did you learn from that you might do differently? Or were they pretty much seamless?
I mean, I think they were very efficient meetings. I think we learned a lot on that DEF transaction in general, about how do we think about utility securitization bonds? How do we benchmark them? What do we compare them to? And how do we register them and get them rated, and how do we ultimately market them? So, we learned a lot. I think it was a successful transaction. That process worked well. I also think that, based on our extensive experience with issuing debt and the way we go about approaching investors, and not just when we're in a deal, but we meet with investors at conferences throughout the year, absent the past year, obviously, puts us in a very good position that we could do this transaction and deliver a very successful transaction to this commission for approval, with or without that act of involvement.
And let me ask you this. Yesterday, I raised the question of whether you felt that the commission could bring on Saber Partners, say, as their financial advisor, if we were to go with the structure that's been proposed by Duke. And you seem to feel at that time they might have a conflict because they serve as financial advisor to the public staff. Of course, neither Saber nor anyone else seems to share that perception based upon testimony I heard today. Do you remain of the opinion that you stated yesterday that there would still be a potential conflict? And is that a conflict that you feel needs to be addressed?
I still do believe it would be a conflict. As I mentioned yesterday, Duke's looking out for its customers here. Certainly, our interests are aligned here, and the commission staff is looking, or the public staff is looking out for customer interests, right? And the commission is looking at both the viability of the utility as well as the customer impacts, right? And so I think if you were to hire either Guggenheim, our advisor today, or if you were to hire the Saber Partners, I would see that as equally being, either one of those would potentially, or would be a conflict.
And last question. We had some discussion yesterday about the certification that Duke would envision providing. And of course, you've heard considerable testimony today about certification being provided by a financial advisor, independent entity that would be looking out for ratepayers. Do you see those being in conflict, or do you consider that they might both be provided? That there might be two opinions? Understand what Duke's opinion would be in terms of, because I'm clear based upon your testimony yesterday.
I certainly, as we proposed, the certification would come from the companies. And as I said yesterday, and I would still support today, that, we believe that that's really the only certification that the commission really needs to base a decision on, right? We propose to certify to a level that is more stringent, we believe, than what we certified to in Florida, that lower cost standard. We have agreed that we have proposed that we would certify to a lowest storm recovery charge standard here. And we stick to our position that, we think that's enough for the commission to make a decision on, because we don't make that representation, we don't make that certification to this commission on any other debt issuance. Right? And so that should give an added level of comfort that, we're committed we're committed to delivering the best result for customers in the state of North Carolina.
Thank you, Mr. Heath. Madam Chair, I don't have any further questions.
All right, Mr. Heath, just following up very quickly on the last few questions that Commissioner McKissick asked of you, the certifications. So I understand the company's position on the certification it would provide, and it's proposing a more stringent certification than that which was offered in the Florida transaction. Remind me, were there any other certifications given in the Florida transaction? Was there just, I'll leave it at that.
There were. The underwriters provided certifications, as well as the FPSC advisor. They were not provided to us. So those certifications were given to the commission itself. I think our attorney saw them on the day of the hearing, but we don't have them, and we received.
Okay, so that would be a difference between what the company is proposing to do in this case versus the transaction in Florida. Those two certifications would not be involved here as proposed by the company. Okay. And is that consistent with neither of those? Well, I guess I won't ask the next question, but respond to my first question.
Yeah, so our proposal here is that we give a certification, and that certification is to a higher level than what we provided in Florida. So we believe it makes the other certificates unnecessary, but as I said yesterday, if someone were to provide certificates to you, we don't say ignore them, but we just say that we believe in the financing order, the only certificate that should be required and should be a necessary condition to the issuance of the bonds be the company's certificate.
Okay, thank you for clearing that up for me. All right, questions on the commissioner's questions? Public staff?
Yes, please, Chair Mitchell, and thank you for all those questions. I did want to start off first, if I could, on the Florida note. We've talked. I believe Mr. Heath, you indicated that what the company here is proposing is similar as many of the protections or many of the aspects of the Florida transaction. I guess it's just been noted, of course, that the certifications here are different than in Florida. That's correct. That the company's proposing are different in Florida. That's correct.
That's correct, but the reason being that the company has proposed to certify to a higher standard.
And just to be clear, the company has been arguing that the commission does not have the authority. Well, excuse me, and you can correct this if you will. The company's been arguing that the commission doesn't have the authority under the so-called catch-all provision to add a lowest cost standard to get the type of certification that the company is now indicating that it will provide. I know you started out your testimony by being confused about, well, let me not go into that. Can you comment on that?
Yeah, the statute here requires a lowest cost standard, and we will certify to that standard that is required by the statute. I don't know why that's,
okay. Go ahead if you need to. I'm not trying to cut you off.
No, that's basically the point. The statute here is lowest cost. It's lowest storm recovery charge consistent with market conditions at the time the bonds are priced and in accordance with the terms of the financing order, and that's what we are proposing to certify to.
So is that a lowest in fact standard? That you've got the lowest at that time?
That is the lowest storm recovery charges consistent with market conditions. So now, there was some discussion in Witness Klein, and I think maybe Witness Esera, and maybe another one of the public staff consultants' testimony about imposing a more stringent, absolute kind of standard is kind of the way I read it. And I would point to Witness Klein's testimony that there are no absolutes in this world, and certainly not in the financial markets. So, we can certify to the statutory standard, but I don't think the statutory standard should be broadened beyond what it says today.
So is the company willing to give a certification that's greater than the statutory standard of North Carolina, or that meets the statutory standard of North Carolina?
We are willing to give a certification that meets the statutory standard.
All right. Now, and thank you for that. Now, in Florida, you mentioned that it was a very similar transaction, but as we discussed yesterday, and there are any number of protections in the transaction documents that are not included. Isn't that correct?
Well, there was one specific one that we pointed out that, where the commission, I think it was around approval of the termination of the companies as servicers. And so as we understood best practices, and what was in transaction documents and from prior transactions, specifically Florida, we did not really understand that particular feature to be something that the commission was going to want to take on as a best practice. So we provided these transaction documents to the commission for review as part of our petition. And if they would like that language in there, we would not be opposed to that.
And thank you. And just a couple more questions. There were questions by the commissioners related to how things went in Florida and conversations. Did you hear, Commissioner, during the commissioner questions, did you hear Witness Fichera's response to my questions about operating within guardrails, within the confines of the bond team, but yet being able to having financial advisors being able to do due diligence?
I did, but as I mentioned earlier, in my response to one of Mr. Jeffrey's questions was this idea of securities law liability and entanglement, and we have very significant concerns about parties that don't bear liability under the securities law having direct conversations on a bilateral basis with investors.
And just on that securities law aspect that you mentioned, will Duke Energy Carolina and/or Duke Energy Progress indemnify their issuer, the SPE issuer, for any securities law liability?
I would have to have that conversation with my counsel. I'm not sure how we would see that overall.
Okay. I've got a number more questions based upon the commission questions. I do appreciate your time. Were there any other items not included in the company's proposal here in North Carolina that were included in Florida that you would like to speak to?
Can you be more specific?
Well, I guess we've talked about the certifications and the standard of certifications. We've talked about customer ratepayer protections that are not in the transaction documents. Is there anything else that we need to discuss?
Not to my knowledge, no.
All right. Thank you. Thank you so much for that. You got some questions about the makeup of the bond team, and one thing that has kind of been, I think, going on in my mind a bit is obviously the commission in this instance can take whatever route it decides. It's the decider. It gets to write the financing order. We're before the commission now. Let's say for whatever reason that the commission decides, okay, for whatever reason, and the commission can decide if it wants to do it, but doesn't want to be a joint decision maker on the bond team. Then what happens, in your view?
If the commission were to decide it did not want to be a joint decision maker in terms of there would still be a bond team, or are we saying that the commission goes back to Duke's original proposal of an issuance advice letter process?
Well, I guess two questions. Number one, would there be a bond team?
Well, the commission has to make that decision, right? So if they say there's no bond team, and they would accept our initial proposal that we laid out in our direct testimony of doing the transaction and bringing an issuance advice letter to the commission, to kind of a couple months, or not a couple months, but a few weeks before going into the actual market and issuing the securities. If we were to present this, a draft issuance advice letter with a indicative pricing and actions that we have taken to date and what we expect to do to complete this offering, and then we come back with an actual issuance advice letter after the fact. That could be one route if the commission again approves that. If they want some form of bond team, we would have to see what the bond team so ordered would be. We have to understand what the order says around a bond team.
Okay. And one of the questions that you received, I believe it's from Commissioner McKissick, related to potential conflicts of the parties, et cetera. And you had commented upon Saber Partners, and I think the question at some point in time came up I don't know if entanglements came up in that different context or not. But is it your understanding? You've heard the testimony from witness Fisher today, and you indicated that he kind of came back around, I guess, on his response on that. You're clear that witness Fisher is not, the Saber Partners team is not being paid on a kind of a performance-based contract in this instance? I mean, it's not based upon a percentage of savings or anything like that, based upon witness Fisher's testimony?
I don't know what the arrangement specifically is, but yeah, I think that was what I heard. It's not a contingent type thing, but I don't really know what the arrangement specifically is and what the fee level is. We put some estimates in in my exhibit based on our experience in Florida from having an active commission advisor, at least, involved there.
But other than being an advisor to in this instance the ratepayer advocate, are you aware of any other interest other than doing a good job that Saber might have in this scenario?
Other than doing a job, we talked about earlier today about underwriters, right? They're incentivized to do a good job because they want repeat business. So I guess I could see that as a motivation too, right? I mean, there's been a fair amount of talk about, future securitization issuances because of future storms, and that may be likely. And I would guess that, they would want to be seen as doing a good job and position themselves for future advisement on those kind of transactions.
And thanks for your patience. I just have 2 or 3 more quick ones, hopefully. One of the comments that you made to the commissioners related to kind of the authority that they came up was related to kind of the authority that they're giving up and the nature of these bonds. And so, as we discussed yesterday, you are aware that these are AAA bonds for a reason, right? Because you stated that after the financing order, the bonds are issued, there's a statutory pledge that neither the state nor the commission may impair the rights of the storm recovery bond owners. Isn't that correct?
Yes, it is.
And there's a requirement that the commission will not amend or modify or terminate the financing order. Is that correct?
I believe that's correct.
And that there's a mandatory periodic true-up mechanism to adjust storm recovery charges to ensure that the bondholders get paid.
That's correct.
And if somebody doesn't pay their bill, it goes on to everybody else.
Yes.
and it's it's considered non-bypassable storm recovery charge.
Yes.
And then finally, even if a customer elects to purchase electricity from an alternative electric supplier following a fundamental change in regulation of the public utilities, the bondholders still have to be paid.
The charges still have to be collected.
The charges still have to be collected. Good point. Yeah, correct. All right, and then 2 final points. Just to be clear, the certification that and we talked about Florida in here. In Florida, there were certifications given by 3 different types of folks. One was a lower level type certification in Florida because it was just considered that it was, you heard witness for share today, it's kind of a self-certification. I mean, it's helpful, but the second certification that was received was from the underwriter, and that was the lowest in fact certification, is my understanding. And then the third was from the investment advisor, in this instance, Sabre, on behalf of the commission. And so there were 3 there, one from the company, a little lower standard, and then from the underwriter and from the investment from the advisor, and those were lowest in fact. And then, is that correct?
I believe that was the case. Yeah. Again, I did not get to see those personally. I did not see the certification from either Sabre Partners or from the underwriters.
Okay. And it may be, I don't even know if a DEF gave a certification in that instance. I think they did, and I thought that's what I heard you said. But if that's not,
we did.
If that's not okay, and then and again, the North Carolina statute and the Florida statute very similar, correct?
I believe so. Yes.
And then finally, on these certifications, the company has offered to give a certain level of certification. Casting no aspersions, I can't quite tell what level we're at, if it's lowest impact or a so-called statutory standard according to the company. But take this analogy, if you will. You go to a doctor and you want to get a second opinion. In this instance, don't you want to go to a doctor who's going to say, yes, go get a second opinion, and I want you to.
Yeah, I think I said earlier that other people can provide certifications if to the commission, and the commission shouldn't just ignore them or throw them away, but the commission should only need to rely on the company's certification, and because it is a lowest charge or is a lowest storm securitization charge consistent with market conditions, and it covers the structuring, marketing, and pricing of the bonds.
Very good. And final question: you may have heard earlier, and we talked about Duke Energy Florida. It was Public Staff Esera Redirect Exhibit 1, which was the transcript from the public hearing, and there was a 5-minute video there, kind of attached to it at the end. But you heard what was stated about Ms. Triplett, who works for Duke Energy Florida, and how everything came together. It wasn't, quote, "This fantastic outcome is no accident." It's et cetera, et cetera. Are you familiar with that?
Yes.
And do you disagree with that?
No, it was a fantastic outcome. And I think everyone agrees. I mean, the numbers in that transaction and relative to other deals speaks for itself. I think we think that transaction was a huge success, and we have put forth a petition in this state, in this proceeding, that very much looks like the Florida transaction.
But as we stated just at the very beginning of this, the company's proposal is not exactly like the Florida model. Is that right?
Correct, and I never said exactly.
Perfect. Exactly. All right. Well, thank you, Mr. Heath. I appreciate your time. Thank you so much.
Thank you.
right, Mr. Jeffries.
Thank you, Chair Mitchell. Just a couple. Mr. Heath, at the risk of beating a dead horse, I want to beat this certification horse one last time. Duke's commitment in your testimony, in both live and pre-filed, is that you intend to certify to the lowest cost consistent with market conditions at the time the bonds are issued. Am I correct about that?
That is correct.
Okay, and so market conditions would be baked in to that certification at that point, right?
Yes.
Okay, now when I learned about adjectives in elementary school, I learned about, lowest is an absolute, right? You can have low costs, or you can have lower costs, or you can have lowest costs. So you're going to certify to lowest cost, correct?
That is correct, yes.
Okay, at the time of issuance, is there a more stringent standard? I mean, is there something lower than lowest?
Not to my knowledge, no.
Okay, thank you. That's all the questions I have, Chair Mitchell.
All right, Mr. Heath, I've got to ask you one more, and I am not trying to prolong this proceeding, and we will finish today in just a few minutes, but I'll ask my question, and then I'll allow counsel to ask questions on my question if they need to. But I just want to be sure I'm clear on the certification, since we've talked about it so much now. The certification, as I understand it, given in the Florida transaction, was that the at least in the nuclear asset recovery case, was that cost was lower the cost of the structured finance was lower than the traditional method. And that is not the same certification being given in this North Carolina proceeding. Do you understand those two things correctly?
That's exactly right. And
okay.
The certification that we were prepared to give in this proceeding for this issuance, we believe, is a higher standard. I mean, it's lowest compared to, like, lowest storm cost consistent with market conditions versus lower cost than traditional recovery. Those are vastly different, right?
All right, I didn't mean to interrupt you. Go ahead. If I interrupted you, finish your sentence. I just wanted you to explain that distinction.
No, that was it. That was all.
Okay, all right, that was it. Counsel, y'all have questions on my question?
No, Chair Mitchell.
Okay.
Not for the company.
Public staff. If you got a question, you got to ask it, Mr. Creech.
Thank you. I think that's I greatly appreciate that. I do need to go back to Florida here. I just want to make sure that we I couldn't quite hear your question, Commissioner Chair Mitchell, when it first started out, but I heard Mr. Heath. Mr. Heath, this question directed to you. So in Florida, how many certifications were given?
By all parties, by the company,
by all parties, by all parties that you're aware of.
There were 3 to my knowledge. So the companies, the underwriters, I believe the underwriters gave one together, and then the commission advisor.
So there were 3.
3 if the underwriters certified together, 4 if they certified individually.
And how many certifications is the company suggesting here in North Carolina?
All right, Mr. Creech, you are straying afield from my question. So I'll let him answer your question, but then.
In this proceeding, because the companies are willing to certify to the lowest storm cost charges, or the lowest charges consistent with market conditions at the time the bonds are priced and in the terms of the financing order, we are proposing a single certification from each of the companies. So one from DEC, one from DEP.
Is that still the case if there's a single, okay, that's fine.
Yes, because the charges are borne by DEC and DEP customers.
So in Florida, one was given because there was one Duke entity. In North Carolina, there are two. But in terms of remaining certifications, in Florida, there were 3 remaining, and you're suggesting here in North Carolina there'd be no more remaining certifications after that, after the conference.
Correct.
Thank you, Chairman.
All right. With that, I believe we are at the end of the examination of Mr. Heath. Mr. Heath, we appreciate your time and your patience. You may step down. I don't believe we need to handle any evidentiary issues for this witness. Mr. Robinson, Mr. Jeffries.
I agree. I concur, Chairman.
Okay. All right, Mr. Heath, you are excused. Thank you very much.
Thank you. Have a good weekend.
All right, so we have come to the conclusion of the proceeding. I will ask counsel if there are any procedural issues to be addressed before we get to the pending motion.
Chair Mitchell, I have one, I guess, preliminary one, and I think will be dependent upon your ruling on the company's motion for a temporary waiver and extension of time. So right now, the current deadline for comments, briefs, or revisions to the company's proposed financing orders is currently scheduled for February 8th. In the event that the commission opts to grant the company's motion for that extension of time for the commission to issue the order until April 9th, the companies would request that the deadline for those comments, et cetera, be due February 18th, which would be an additional 10 days from the February 8th. I can state that I conferred with parties prior to the hearings today, and no party objected to this proposed request.
All right, thank you, Mr. Robinson. Before I rule on the motion as to the waiver of the 135-day period set forth in the statute, I want to hear from Ms. Kress that you, as to whether your client has any position on this matter.
We don't object.
Okay. All right. With that, I will, Mr. Robinson, I'll allow the company's motion as to the 135-day statutory period. I will also allow the motion or the request as to extension of time until February 18th for the comments on the proposed financing orders. We will, although I've ruled orally on the motion, we will issue an order just for clarity of the record, and that'll be forthcoming.
Thank you.
All right. With that, any additional matters before we adjourn?
Nothing from the companies.
All right. Mr. Grantmeyer, Mr. Creech.
Thank you so much. Thank you.
Nothing more from the public staff.
All right. All right. Well, thank you, everybody, for your participation. This has been an interesting and a challenging proceeding. I appreciate the attention and the effort that you all have put into this one, and appreciate everybody's hard work to conduct this over video conference technology. Also want to say thank you to our court reporter. Thank you for your patience and hanging in there with us. All right. With that, we will be adjourned. Thank you, everybody.
Thank you.
Thank you, Chairman.